you own. Yeah, everything. Estate planning isn't just for the rich or the old. If you have a bank account, a car, a pet, or a kid, this is for you. Here are 3 things every adult needs: a will, a power of attorney, and a healthcare directive. And no, it doesn't take months. You can set this up in a short period of time. Without a plan, your loved ones could face court delays, legal battles, and stress right when they're grieving. Don't leave a mess. Start your estate plan today. Even a basic plan is better than nothing.
Most parents think they're being smart when they add their child's name to their property deed. They believe it's a simple way to avoid probate, save on taxes, or just make things easier when they're gone. But here's the harsh reality that real estate attorneys see every single day. This well-intentioned decision can absolutely destroy your family's financial future. We can tell you that some of the most devastating financial disasters we've witnessed started with parents who thought they were doing the right thing by adding their kids to the deed. These aren't complicated legal loopholes or obscure tax codes we're talking about. These are real families who lost everything because of one simple mistake. Now, before you think this doesn't apply to you because your family gets along perfectly, or because your child would never do anything to hurt you, let me stop you right there. The families I'm about to tell you about thought the exact same thing. They trusted completely. And that trust ended up costing them their homes, their life savings, and in some cases their relationships with their children forever. Today, I'm going to walk you through 5 devastating consequences that happen when you add your child to your deed. And trust me, by the end of this, you'll understand why every estate planning attorney cringes when they hear about parents doing this. We're going to cover real-life examples, the legal nightmares that follow, and most importantly, what you should be doing instead to protect your family's future. But first, let me share something that might shock you. According to recent studies, over 60% of parents have considered adding their children to their property deeds, and nearly 30% have actually done it. That means millions of families across the country are sitting on a financial time bomb, and most of them have no idea. The problem isn't just that this strategy backfires. The problem is that when it goes wrong, it goes catastrophically wrong. We're talking about losing your home while you're still living in it, facing massive tax bills you never saw coming, and watching your children fight in court over property that was supposed to bring your family together. Let me paint you a picture of what this looks like in real life. Picture Sarah, a 72-year-old widow who added her son Michael to her deed 3 years ago. She thought she was being responsible, making sure her house would pass to him without any legal complications. Michael seemed like the perfect choice. He was financially stable, married with 2 kids, and had always been the responsible one in the family. But here's what Sarah didn't anticipate. A few years after she added Michael to the deed, he was named in a lawsuit related to a failed business partnership. Even though the dispute had nothing to do with Sarah or her property, the court issued a judgment against Michael personally. And because his name was on the deed, the judgment creditor placed a lien on the home. Sarah, who had lived in that house for 45 years and raised 3 children there, suddenly found herself unable to refinance, sell, or even borrow against her own home, all because of a legal issue she had nothing to do with. This isn't some rare, you won't believe how many families lose thousands just because of simple estate planning mistakes. Here are the top 5 you need to avoid. Mistake number 1, not having a will at all. Over 60% of adults don't have one. If you die without it, the state decides who gets your stuff, not you. Mistake number 2, forgetting to update beneficiaries. Your ex-spouse could inherit your life insurance just because you forgot to update a name. Seriously. This happens all the time. Mistake number 3, thinking a will avoids probate. It doesn't. A will still goes through court. To avoid that, you need a trust. Mistake number 4, not planning for incapacity. Who handles your finances or makes medical decisions if you're in a coma? If you don't name someone, the court will. And mistake number 5, DIY estate plans. One wrong word or signature could make your whole plan invalid. Saving a few bucks now could cost your family everything later.
A trust is a legal document that acts like a bucket to hold assets and contain a set of rules and instructions. The person in charge of that bucket is called the trustee. There are several types of trusts, such as a revocable trust, an irrevocable trust, a pet trust, a charitable remainder trust, and more. An irrevocable trust is a type of trust that cannot be modified, amended, or terminated without the permission of the grantor's beneficiary or beneficiaries. The grantor can give assets to the irrevocable trust. Doing this makes the irrevocable trust the owner of the assets and removes the grantor as the owner of those assets. The assets no longer belong to the grantor from a tax, estate recovery, and Medicaid perspective, allowing for advanced estate planning techniques. Irrevocable trusts are complicated and should be created by a professional. All forms of trusts are important asset planning and protection tools that have their specific place. For more information on wills or trusts, contact a professional. Have you ever wondered what happens to someone's assets after they pass away? Today, we'll explore the world of probate, breaking it down into steps, as well as looking into the various types that are most appropriate depending on your circumstances. Dealing with assets after a loved one's passing is never easy, but understanding the process can help. Let's break down probate. What is probate? Probate is the formal legal procedure after someone's death, which settles their financial and legal affairs. It is the process that ensures assets are transferred rightly and legally to beneficiaries, and any outstanding debts are settled. But who ensures this process runs smoothly? The crucial role of the executor, that would be the executor, also known as the personal representative. They initiate the probate process, manage assets, settle debts, and ensure the rightful distribution of assets. It's a significant role, oftentimes demanding guidance from experienced probate attorneys. But how do you get started with probate? Let's walk through it step by step. Step 1. Initiating the probate process. Everything begins with appointing a personal representative, either named in the will or chosen by the court. They file a petition for probate, and here, professional legal guidance can be invaluable. Step 2. Inventorying the estate. The representative then takes stock of the deceased's assets, everything from real estate to bank accounts. Step 3. Settling debts and taxes. Before beneficiaries get anything, all debts and taxes must be settled using the estate's assets. Step 4. Distribution. Finally, the remaining assets are distributed according to the will or state laws if there's no will in place. Probate isn't one size fits all. There are different types for varying circumstances. Types of probate. Formal probate. This structured, judge-overseen process is ideal for complex estates or when beneficiaries have disputes. Informal probate. A simpler, quicker process fit for straightforward estates with a valid will and no disputes. Special administration. This method is for when immediate action is required or when full estate administration isn't necessary. Probate may seem complex, but with experienced guidance, you can be sure your estate is managed properly. Be sure to check out additional articles on probate or inquire about a consultation on the Heritage Law Office website in the description below. Also, don't forget to subscribe to the channel for more helpful legal content, and please hit that like button.
In this video, we'll talk about what you need to know about the advantages and disadvantages of establishing a trust. If you're contemplating setting up a trust, this video is designed to help you make a more informed decision. Let's get started. What is a trust and why is it important? First, let's answer a common question. What exactly is a trust? A trust is a legal arrangement that allows a third party, called a trustee, to hold and manage assets on behalf of beneficiaries. Trusts are commonly used in estate planning, wealth management, and asset protection. They can help individuals achieve various financial and personal objectives, such as providing for loved ones, reducing taxes, or ensuring privacy. Now that you understand what a trust is, let's move on to explore the different types of trusts you can establish. There are many types of trusts, each serving a specific purpose. Some common types include revocable living trusts, irrevocable trusts, testamentary trusts, special needs trusts, charitable trusts. Each type of trust has its own set of advantages. Let's take a closer look. Trusts offer a multitude of benefits. First, they give you significant control and flexibility over how your assets will be managed and distributed. You can establish specific terms and conditions, aligning your trust seamlessly with your unique goals and needs. Another major advantage is probate avoidance. Probate is a legal procedure that validates a will and distributes assets. Trusts, however, bypass this process entirely, enabling a faster and more confidential asset transfer to your beneficiaries. Tax benefits are also on the table. Some trusts can substantially minimize estate, gift, and income taxes. For instance, an irrevocable trust can effectively reduce your taxable estate, offering potential tax savings for your beneficiaries. Lastly, trusts are excellent tools for asset protection. They can shield your assets from creditors, lawsuits, or even divorce proceedings. While trusts offer significant advantages, it's essential to also consider the disadvantages. Complexity and cost. Even though trusts are highly beneficial, they come with some drawbacks. The most glaring ones are their complexity and associated costs. Establishing a trust requires experienced legal guidance, and there may be some administrative fees involved. Additionally, some trusts, particularly irrevocable ones, lack flexibility. Once established, they can't be easily changed or dissolved without the beneficiary's consent. Finally, trusts can sometimes fuel conflicts among family members or beneficiaries, especially if the trust is perceived as unfair or if the trustee is not acting responsibly. Understanding both sides of the coin can help you make a well-informed decision about whether a trust is right for you. A trust can offer numerous advantages, such as control over asset distribution, probate avoidance, potential tax benefits, and asset protection. However, there are some drawbacks to consider, like the complexity and cost of establishing and maintaining the trust, potential irrevocability, and the possibility of conflicts among beneficiaries. For more information on each type of trust, explore some of our other videos where we break these down individually. If you found this video helpful, remember to like and subscribe. Thank you for watching.
Join us as we take on the challenge of organizing the essential documents needed for a comprehensive estate plan and learn how to avoid costly mistakes along the way. Estate planning is often viewed as a complex and daunting task, but having a comprehensive plan in place can provide peace of mind and financial security for you and your loved ones. If you don't have a proper estate plan in place, your family may be left to deal with the fallout, which can lead to lengthy and costly probate battles, family disputes, and even financial devastation. Without a clear plan, your assets may not be distributed according to your wishes, and your loved ones may be left with a huge mess to sort out. In addition, if you become incapacitated, your family may have to go to court to get a conservatorship, which can be a lengthy and expensive process. Furthermore, your medical wishes may not be respected, and your family may have to make difficult decisions on your behalf without knowing what you would have wanted. Moreover, without a comprehensive estate plan, your business and personal assets may not be protected, leaving them vulnerable to creditors, lawsuits, and other risks. In the worst-case scenario, not having a proper estate plan can lead to family feuds, lawsuits, and even financial ruin. It's a heavy burden to place on your loved ones, and it's one that can be easily avoided with a little planning and foresight. A comprehensive estate plan consists of several essential documents that work together to protect your assets and ensure your wishes are carried out. These documents include wills, trusts, powers of attorney, and healthcare directives. Each document plays a vital role in ensuring that your assets are distributed according to your wishes, your loved ones are protected, and your medical wishes are respected. A will is a legal document that outlines how you want your assets to be distributed after you pass away. It's a crucial document that ensures your wishes are carried out, and it can also appoint guardians for minor children. Trusts, on the other hand, are legal arrangements that allow you to transfer assets to beneficiaries while minimizing taxes and avoiding probate. Powers of attorney give someone the authority to make financial and medical decisions on your behalf if you become incapacitated. Healthcare directives, also known as living wills, outline your medical wishes if you're unable to communicate them yourself. Each of these documents is essential to a comprehensive estate plan, and they work together to provide a complete picture of your wishes and intentions. By having all of these documents in place, you can ensure that your loved ones are protected, your assets are distributed according to your wishes, and your medical wishes are respected. It's a vital step in planning for the future and avoiding costly mistakes. By having a comprehensive estate plan in place, you can rest easy knowing that your loved ones will be protected and your wishes will be carried out. If you don't already have a comprehensive estate plan in place, we encourage you to take the first step and schedule a consultation with an estate planning attorney today. It's a small step that can provide huge peace of mind and financial security for you and your loved ones.
Most families think they've got their estate planning sorted out when they write a will. But here's the harsh reality. They're setting their loved ones up for months of legal headaches, thousands in unnecessary fees, and family drama that could tear relationships apart forever. I've seen it happen countless times, and today I'm going to show you exactly why the choice between a will and a trust could be the difference between leaving your family a gift or leaving them a nightmare. Look, I get it. When most people think about estate planning, they immediately jump to wills because that's what everyone talks about. Your parents probably had a will, your grandparents had a will, and every movie you've ever watched shows some dramatic will reading scene. But here's what nobody tells you. Wills are actually one of the worst ways to transfer wealth to your family. Now, before you think I'm completely crazy, let me explain exactly what I mean. I'm going to break down the real differences between wills and trusts in a way that actually makes sense, without all the legal jargon that usually makes your eyes glaze over. By the end of this video, you'll understand why most wealthy families use trusts, and more importantly, how you can protect your family the same way. But first, let me share a story that perfectly illustrates why this matters so much. Meet a woman named Sarah. Her dad had passed away suddenly, leaving behind a house, some investments, and what everyone thought was a simple will. Sarah assumed everything would be straightforward. After all, her father had been organized, he'd written everything down clearly, and the will seemed to cover all the basics. But what happened next was a complete disaster. The will had to go through probate court, which meant every single asset became public record. Suddenly, distant relatives she hadn't spoken to in years started coming out of the woodwork, claiming they deserved a piece of the inheritance. The legal fees started piling up. First, it was a few $100s here and there. Then it became thousands. The house couldn't be sold because it was tied up in probate. The investment accounts were frozen. And Sarah found herself spending every weekend dealing with lawyers, court filings, and family members who were suddenly very interested in her father's money. 18 months and $23,000 in legal fees later, Sarah finally received what should have been hers from the beginning. But by then, the stress had taken its toll. Her relationship with her brother had completely fallen apart over disagreements about the estate. Her mother was devastated by all the family conflict. Sarah wouldn't wish that experience on her worst enemy. The crazy part? All of this could have been completely avoided if her father had used a trust instead of a will. While Sarah was dealing with lawyers and court dates, families with trusts were quietly transferring assets to their loved ones without any of that drama. So, what exactly is the difference? And why does it matter so much? Most people think a will and a trust do the same thing, just with different paperwork. That's like saying a bicycle and a Ferrari both get you from point A to point B. Technically true, but you're missing the entire picture. Here's the thing that blows most people's minds. A will doesn't actually avoid probate court. In fact, having a will guarantees you'll go through probate. It's like having a roadmap that leads you straight into the most expensive, time-consuming legal process possible. When you die with a will, here's what actually happens. Your will becomes a public document that gets filed with the court. Every asset you own, every debt you owe, and every person who benefits from your estate becomes public information that anyone can access. Your nosy neighbor, that ex-business partner you had a falling out with, or even complete strangers can walk into the courthouse and read all about your family's private financial business. But that's just the beginning of the problems. Probate court moves at the speed of molasses on a cold day. We're talking months, often years, before your family can access the money and property you intended to leave them. During this entire time, your assets are basically frozen. Your family can't sell the house, can't access investment accounts, and can't make any major financial decisions without court approval. And let's talk about the costs, because this is where it gets really painful. Probate fees typically run between 3 and 7% of your total estate value. So, if you're leaving behind a $400,000 house and some investments, your family could be looking at $20,000 or more in fees before they see a single penny. That's money that should be going to your kids or grandkids, but instead it's padding some lawyer's bank account. Now, here's where trusts completely change the game. Think of a trust as a special container that holds your assets while you're alive and then seamlessly transfers them to your beneficiaries when you're gone. No court involvement, no public records, no waiting periods, and dramatically lower costs. When you create a trust, you're essentially creating a separate legal entity that owns your assets. You remain in complete control as the trustee while you're alive, so nothing changes in your day-to-day life. You can still buy, sell, and manage everything exactly like you always have. But when you pass away, a successor trustee you've chosen steps in and distributes everything according to your wishes, usually within a matter of weeks. Think about it this way. You wouldn't leave your family a gift wrapped in barbed wire, so why leave them an inheritance wrapped in legal red tape? The choice between a will and a trust isn't just about paperwork. It's about whether you want to leave your loved ones a blessing or a burden. Don't make the same mistake Sarah's father made. Your family deserves better than months of court battles and thousands in unnecessary fees when you could give them the gift of a smooth, private transfer that protects their relationships and their inheritance.
In this video, we will discuss the essential components of a strong estate plan and how each component can help you ensure your wishes are fulfilled. Creating an estate plan is crucial to ensure your assets are distributed according to your wishes after you pass away. Without an estate plan, the state will determine how your assets are distributed, which may not align with your intentions. Having a clear plan can give you peace of mind and prevent potential conflicts among your heirs. A will is a legal document that outlines how you want your assets distributed after your death. It is essential to include key elements such as the designation of an executor, guardianship for minor children, and specific bequests. A well-drafted will can ensure your loved ones are taken care of and your assets are distributed as you desire. Trusts are another vital component of an estate plan. They come in different forms, such as revocable and irrevocable trusts. Trusts can help manage your assets during your lifetime and ensure they are distributed efficiently after your death, often avoiding probate. By setting up a trust, you can control how and when your beneficiaries receive their inheritance, protect assets from creditors, and potentially reduce estate taxes. Powers of attorney are critical for managing your affairs if you become incapacitated. Financial powers of attorney allow someone to manage your financial matters, while healthcare powers of attorney enable someone to make medical decisions on your behalf. Having these documents in place ensures your affairs are handled according to your wishes, even if you are unable to communicate them yourself. Healthcare directives, including living wills and healthcare proxies, are essential for outlining your medical preferences, in case you cannot communicate your wishes. These documents guide your loved ones and healthcare providers in making crucial medical decisions, ensuring your healthcare wishes are respected. Ensure your assets go to the intended recipients by updating beneficiary designations on accounts such as life insurance policies, retirement accounts, and payable on death bank accounts. This step helps avoid probate and ensures a smooth transfer of assets. Regularly updating these designations can prevent unintended beneficiaries from inheriting your assets. It's important to review and update your estate plan periodically. Major life events such as marriage, divorce, the birth of a child, or the death of a loved one may necessitate changes to your plan to reflect your current wishes and circumstances. Regular reviews help ensure your estate plan remains aligned with your evolving needs and goals. In summary, a strong estate plan includes a will, various types of trusts, powers of attorney, healthcare directives, and updated beneficiary designations. Regularly reviewing and updating your plan ensures it remains aligned with your wishes. Contact us to learn more about creating a comprehensive estate plan tailored to your needs.
Most people think a will and a trust are basically the same thing, just different pieces of paper that do the same job. That couldn't be further from the truth. In fact, understanding the difference between these two could save your family thousands of dollars and months of legal headaches. I've seen families torn apart because they chose the wrong option, and I've also seen others sail through difficult times because they made the right choice. So today, I'm going to break down exactly how a will differs from a trust, when you should use each one, and which option might be right for your specific situation. By the end of this video, you'll have complete clarity on both options and know exactly which path makes sense for you and your family. But first, let me share something that might surprise you. According to recent studies, over 60% of Americans don't have either a will or a trust. That means most people are leaving their family's future completely up to chance. Don't be one of those people. Let's start with the basics. A will is essentially your final instructions. Think of it as a letter you're writing to the world, telling everyone exactly what you want to happen to your stuff after you're gone. It's straightforward, it's simple, and it only kicks into action after you pass away. You can name guardians for your children, specify who gets your house, your car, your savings account, and even your grandmother's antique jewelry. Here's the thing, though, and this is where most people get tripped up. A will has to go through something called probate court. That's basically a legal process where a judge makes sure everything in your will is legitimate and properly distributed. Sounds simple enough, right? Well, probate can take anywhere from 6 months to 2 years, and it's completely public. Anyone can walk into that courthouse and see exactly what you owned and who you left it to. A trust, on the other hand, is like having a personal financial manager that works even while you're alive. You can put your assets into a trust today, right now, and still control everything. You're essentially moving your stuff into this legal container, but you still get to use it however you want. The magic happens when you pass away. Everything in that trust goes directly to your beneficiaries without any court involvement whatsoever. Think about it this way. If a will is like leaving detailed instructions for someone to follow later, a trust is like having that someone already standing there, ready to act immediately. No waiting, no courts, no public records. Your family gets what you intended them to have, and they get it fast. But here's where it gets interesting. Trusts aren't just for wealthy people anymore. You might think you need millions to justify setting up a trust, but that's not true. If you own a home, have retirement accounts, or simply want to avoid the hassle and expense of probate, a trust could save your family significant time and money. The downside? Trusts are more complex to set up initially and typically cost more upfront. You'll need to actually transfer your assets into the trust, which means changing titles and beneficiary designations. It's not difficult, but it does require some paperwork. Wills, meanwhile, are simpler and cheaper to create, but they don't avoid probate and they don't help if you become incapacitated. With a trust, if something happens to you and you can't manage your affairs, your successor trustee can step in immediately. With just a will, your family might need to go to court to get permission to help you. The truth is, many people actually need both. A will can handle things that don't go into your trust, name guardians for minor children, and serve as a backup plan. A trust handles the bulk of your assets and provides privacy and efficiency. The bottom line is this: your choice between a will and a trust isn't just about legal documents. It's about how much control you want over the process, how quickly you want your family to receive their inheritance, and how much privacy matters to you. Choose wisely, because this decision will impact the people you care about most long after you're gone.
In this video, we'll explore how to choose the right executor for your estate, covering key considerations and steps to ensure your wishes are carried out. Choosing the right executor is a crucial part of estate planning. Your executor will manage your affairs, settle debts, and distribute your assets according to your will. Making an informed choice can provide peace of mind for you and your loved ones. An executor has several key responsibilities. They collect and manage assets, pay debts and taxes, and distribute assets to beneficiaries. They must act prudently, be impartial, and maintain detailed records. When choosing an executor, look for trustworthiness and integrity. Your executor should be someone you trust implicitly and who has a reputation for honesty. Financial acumen is also essential, especially if your estate includes complex assets. Organizational skills are crucial, as the executor must handle numerous documents and deadlines. They should also be able to handle stress and make sound decisions under pressure. Availability is another key factor, as the role can be time-consuming. Common choices for executors include family members, friends, and professionals. Family members and friends may have a personal interest in honoring your wishes, but it's important to consider their potential emotional strain and conflicts of interest. Professionals, such as lawyers or trust companies, offer expertise and impartiality but come with costs. Consider the size and complexity of your estate when choosing an executor. A large or complicated estate might benefit from a professional executor. Also, think about family dynamics and whether the person you choose can navigate potential conflicts. Geographical proximity can be beneficial, especially if your estate includes real property. Legal requirements vary by state, but generally, an executor must be of legal age, of sound mind, and free of felony convictions. Some states require executors to post a bond to protect the estate from potential mismanagement. You may also appoint co-executors to share responsibilities, but this can lead to conflicts if they disagree. Alternatives to traditional executors include corporate trustees, who provide professional management, and successor executors, who step in if your first choice is unable to serve. To formalize your choice, include your executor in your will, clearly stating their name and any specific instructions. Communicate your decision with your chosen executor and any successors, and review your will periodically to ensure it reflects any changes in circumstances. Avoid common mistakes, such as choosing an executor out of obligation, overlooking professional help, and ignoring potential conflicts of interest. Make a choice based on suitability for the role. Choosing the right executor requires careful consideration and foresight. To ensure your choice is legally sound and well-informed, consult with an experienced attorney. They can guide you through the process and help you select the best candidate for your needs. Thank you for watching. For more information on estate planning, be sure to subscribe to our channel and visit our website.
Welcome to our series on franchise law. Today, we're discussing the legal aspects of buying or starting a franchise. Understanding these aspects is crucial for making informed decisions and ensuring your business venture is successful. First, what is a franchise? A franchise is a business model where a franchisor grants a franchisee the right to operate a business using the franchisor's brand, products, and systems. The franchisee pays fees and agrees to operate the business according to the franchisor's guidelines. When considering a franchise, there are two primary legal documents you need to be familiar with: the Franchise Disclosure Document, or FDD, and the Franchise Agreement. The Franchise Disclosure Document, or FDD, provides detailed information about the franchisor and the franchise system. It includes the franchisor's history, litigation history, financial statements, initial and ongoing fees, and obligations of both parties. Reviewing the FDD thoroughly is essential. The Franchise Agreement is the binding contract between the franchisor and franchisee. It outlines the terms and conditions of the franchise relationship, including the rights and responsibilities of each party. Key terms to understand include the duration of the franchise, renewal terms, territorial rights, and conditions for termination. Conducting thorough due diligence is critical before buying a franchise. This involves reviewing the FDD, researching the franchisor's history and reputation, and understanding the financial commitments and projections. When buying a franchise, there are several legal considerations to keep in mind: initial franchise fees and ongoing royalties. Understand the total cost involved. Territorial rights and restrictions. Know your exclusive territory and any restrictions. Intellectual property rights. Understand your rights to use the franchisor's trademarks and proprietary systems. Obligations of the franchisor and franchisee. Clarify the support and training provided and expected. Renewal and termination clauses. Pay attention to the terms for renewing or terminating the agreement. Starting a franchise involves several key steps. Ensure legal compliance by registering your franchise and adhering to state-specific regulations. Develop an operations manual outlining how the franchise should be run. Protect your intellectual property by securing trademarks and trade secrets. Financial aspects are important. Explore financing options for buying or starting a franchise and understand the initial investment required, as well as ongoing expenses and royalties. Franchisee support and training are vital for success. Most franchisors provide initial training and ongoing support to help franchisees run their businesses effectively. Take full advantage of these resources. Disputes can arise in any business relationship. Common disputes in franchising include disagreements over territory, fees, and performance standards. Methods for resolving disputes include mediation, arbitration, and litigation. Address disputes promptly and seek legal advice if necessary. In conclusion, buying or starting a franchise involves navigating several legal aspects, from understanding the FDD and franchise agreement to conducting due diligence and ensuring legal compliance. Consulting with a qualified franchise attorney is essential to protect your interests and make informed decisions. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified franchise attorney. See you in the next video. In our last video, we discussed the Medicaid look-back period and potential penalties. Today, we're going to explore important asset protection strategies for Medicaid planning. These strategies can help preserve your assets for your spouse and heirs while ensuring you remain eligible for Medicaid. Why is asset protection so important? When planning for long-term care, it's crucial to balance protecting your assets with meeting Medicaid eligibility requirements. Preserving your assets ensures your spouse and heirs are not left financially vulnerable. Let's dive into some common asset protection strategies. First, irrevocable trusts. Placing assets into an irrevocable trust means you no longer own them, so they aren't counted towards Medicaid's asset limits. This can be a powerful way to shelter your assets. However, remember that once the assets are in an irrevocable trust, you can't access them or change the trust terms. It's essential to work with an experienced attorney to set up the trust correctly. Second, Medicaid-compliant annuities. These annuities convert a lump sum of money into a stream of income. Medicaid-compliant annuities meet specific requirements to ensure they aren't counted as assets. They must be irrevocable, non-assignable, and pay out within your life expectancy. This strategy can be beneficial, but it's important to understand the terms and potential impact on your income. Third, life estates. Creating a life estate means transferring ownership of your home to someone else while retaining the right to live there for the rest of your life. The value of the home is no longer considered an asset for Medicaid purposes. However, if the home is sold during your lifetime, you may receive a portion of the proceeds, which could affect your Medicaid eligibility. This approach requires careful planning and understanding of your state's rules. Aside from these, there are other legal tools you might consider. Long-term care insurance can help cover the cost of nursing home care, reducing the need to spend down your assets. Family caregiver agreements allow you to compensate family members who provide care, which can also help manage your assets within Medicaid's guidelines. It's crucial to consult with professionals when planning your asset protection strategy. An experienced attorney who has dealt with elder law and Medicaid planning can help tailor these strategies to your specific circumstances. They can provide guidance on the best approach for preserving your assets while ensuring Medicaid eligibility. In summary, protecting your assets is a vital part of Medicaid planning. By using tools like irrevocable trusts, Medicaid-compliant annuities, and life estates, you can preserve your wealth for your loved ones. Consulting with a knowledgeable attorney will ensure your plan complies with Medicaid regulations and meets your personal needs. Thank you for watching. If you have more questions or need personalized advice on asset protection strategies for Medicaid planning, consult with a qualified attorney to explore your options.
A charitable remainder trust is an irrevocable trust that provides the donor with income for life and a current tax benefit for planning to donate assets upon their death. The donor gives away assets to an irrevocable trust, and during their lifetime they receive income from the trust. When they die, the remainder in the trust goes to the charities of their choice. When an asset is transferred into an irrevocable trust, it is removed from their estate. As a result, the assets in the trust cannot be recovered by creditors, and no estate taxes will be due upon their death. Additionally, because the assets are no longer owned by the donor, other advanced estate planning methods may be used in conjunction with a charitable remainder trust. Finally, for their generosity, the donor will receive an immediate income tax deduction when the charitable remainder trust is funded. The tax deduction amount is based on the current value of the assets that will go to charity. Irrevocable trusts are complex and must be precise. Be sure to talk with a professional. All forms of trusts are important asset planning and protection tools that have their specific place. For more information on wills or trusts, contact a professional.
Before your student leaves for college, there is one thing most families forget. Not bedding, not textbooks, not a laptop, legal paperwork. Because the moment your child turns 18, the law sees them as an adult, and that changes everything. As a parent, you may still be paying tuition. You may still be covering health insurance. You may still be the first person they call when something goes wrong. But legally, you may no longer have automatic access to their grades, their student account, their medical updates, or even the ability to help in an emergency. So today, we're going through the essential legal documents every college student should consider before leaving for university. This video is for educational purposes only and is not legal advice. Forms and requirements vary by state, so speak with a qualified attorney or check your state and university requirements before signing anything. Here's the privacy gap most families do not see coming. When a student turns 18, parents do not automatically have the same legal access they had when that student was a minor. That means if your student is struggling academically, you may not be able to simply call the school and ask for grades or records. And the same kind of issue can come up with health information. Imagine your student is away at school and has a medical emergency. They are taken to the hospital. You call the hospital, terrified, asking what happened, what their condition is, and what decisions need to be made. But without the right authorization, the hospital may be limited in what it can tell you. That does not mean doctors are trying to be difficult. It means privacy laws apply because your student is now a legal adult, and verbal permission may not be enough, especially during a crisis when your student is unconscious, sedated, overwhelmed, or unable to clearly communicate. That is why these documents matter before move-in day. The first document to ask about is a FERPA release, or student records authorization. This is usually handled through the college or university. It allows the student to give a parent or trusted person permission to access certain education records. This may include grades, billing information, financial aid details, disciplinary records, or other student account information, depending on what the school allows and what the student authorizes. This is important because even if a parent is paying the bill, the school may still require the student's consent before sharing protected education records. So before classes begin, have your student log into their university portal and search for terms like FERPA release, parent access, authorized user, or student records consent. This is not about spying. It is about making sure the family can help when help is actually needed. Now let's talk about medical documents. The first medical document is a HIPAA release form. HIPAA is the federal privacy law that protects health information. A HIPAA release allows your student to name who can receive medical updates. This is the baseline document for communication. It does not necessarily give a parent the power to make medical decisions. It simply helps doctors, hospitals, or other medical providers share information with the people the student has authorized. So if your student wants a parent, guardian, sibling, or trusted family member to be kept in the loop, the HIPAA release is the starting point. The second medical document is a healthcare proxy, medical power of attorney, or advanced healthcare directive. The name depends on the state. This document allows the student to choose someone to make medical decisions if they cannot make those decisions themselves. That is the key phrase. If they cannot make decisions themselves. This is not about taking control away from the student. It is about having a trusted person legally ready to step in if the student is unconscious, incapacitated, or otherwise unable to speak for themselves. And here is the practical tip many families miss. Do not leave these forms sitting in a drawer at home. Keep digital copies on the student's phone. Keep copies in a secure cloud folder. Make sure the parent or trusted person also has access. In an emergency, the best document is the one you can actually find. Next is a durable power of attorney, sometimes called a financial power of attorney. This document allows the student to appoint someone to handle certain financial or legal matters if needed. That could include dealing with tuition issues, bank problems, apartment leases, insurance paperwork, car registration, or time-sensitive documents that require a signature while the student is away. Think about real life. A lease needs to be signed by Friday. A bank account gets locked. Financial aid needs a document corrected. A tuition payment issue pops up while the student is in class, traveling, sick, or unavailable. Without proper authorization, parents may be stuck on the outside, unable to help quickly. A durable power of attorney can create a safety net, but this is also where families should be thoughtful. The document can be written broadly or narrowly. It can be designed to give power only in specific circumstances. It can limit what the appointed person can do. So the goal is not to take away the student's independence. The goal is continuity. The student remains the adult. The student remains in charge. The paperwork simply creates a backup plan. Now let's turn this into a simple checklist. Before move-in day, consider having these documents completed: a FERPA authorization through the university, a HIPAA release form, a healthcare proxy or medical power of attorney, a durable financial power of attorney, and any state-specific forms recommended by an attorney. For storage, keep the physical originals in a safe place at home, such as a fireproof document box. The student should also have digital copies saved securely on their phone. The family should create an encrypted shared folder with copies of the signed documents, emergency contacts, insurance cards, the student ID number, the university health center information, and the contact details for the student's doctor. Make sure the folder is secure. Use strong passwords. Turn on two-factor authentication. Do not just email sensitive documents back and forth casually. And set a real deadline. Not sometime before school starts. Make the deadline move-in day. Actually, make it 1 week before move-in day, because some documents may need signatures, witnesses, or notarization depending on your state. Sending a student to college is a major milestone. It is exciting. It is emotional. And yes, it comes with a lot of logistics. But these legal documents are not about expecting something bad to happen. They are about being prepared. They give students independence while giving families a safe, legal way to help if something goes wrong. With the right paperwork in place, everyone can breathe a little easier. Your student can focus on classes, friendships, and becoming an adult. And you can have peace of mind knowing that if there is an emergency, you are not stuck on the other side of a privacy wall. Before they pack the car, pack the paperwork. It may be one of the most important things they bring to campus.
Seniors must show that they own nothing more than around $2,000. And they must also show that they have not given away money or assets over the prior 5 years. The look-back period, or the transfer penalty, would charge that senior for their generosity. Depending on the size and number of the gifts, the penalty could be substantial. Many wrongly think that there is no penalty for gifts of up to around $15,000 annually. That misunderstanding confuses tax law with Medicaid law. The Medicaid rules are entirely different from the tax rules. In the Medicaid context, gifts of any amount that are given during the look-back period can be penalized. There are exceptions, including gifts to spouses and siblings under certain circumstances, disabled children, and children who are caregivers and who live at home with the elder for a span of time. But overall, gifts and Medicaid do not belong together. The Medicaid rules are complicated, and the consequences for mistakes can be very costly. There are a number of options to protect assets and still qualify for benefits, but these options must be weighed with great care. This is why it's best to consult attorneys who are experts in Medicaid law. Contact Heritage Law Office today for more information on long-term care planning, Medicaid, and gifting. An estate plan is a collection of legal documents and strategies that outline how your assets and affairs will be handled in the event of your death or incapacity. Key components of an estate plan include wills, trusts, powers of attorney, and healthcare directives. There are several compelling reasons to have an estate plan. First, it ensures that your wishes are followed regarding the distribution of your assets and care of your dependents. Second, it protects your assets from unnecessary taxes, expenses, and legal fees. Third, it provides for your family by outlining your intentions clearly, reducing stress and uncertainty for your loved ones. Without an estate plan, your estate may face significant legal complications and delays. This can lead to increased costs and taxes, reducing the inheritance you leave behind. Additionally, the absence of clear instructions can result in family disputes and conflicts over your estate. Starting an estate plan involves several key steps. Begin by taking inventory of your assets, including property, investments, and personal belongings. Decide on your beneficiaries and how you want your assets distributed. Next, consult with an experienced attorney to draft the necessary legal documents, such as a will or trust. Regularly review and update your estate plan to reflect changes in your life, such as marriage, divorce, or the birth of a child. An estate plan isn't just about distributing your assets. It also includes making decisions about your healthcare and financial affairs if you become incapacitated. Powers of attorney and healthcare directives allow you to appoint someone you trust to make decisions on your behalf, ensuring your wishes are respected. Having an estate plan is crucial for ensuring your wishes are respected and your family is protected. Don't wait until it's too late. Contact an attorney to start your estate plan today. This proactive step can provide peace of mind and security for you and your loved ones. Thank you for watching. Make sure to like and subscribe for more. Probate is the legal process that occurs to your estate after you pass away. During this legal process, a court will monitor the process of paying your debts and distributing your estate to the proper heirs. The probate process will take several months at minimum to complete and may take longer, depending on the complexity of your estate. Through proper planning, probate can be avoided, saving time and money. Tools such as a trust, life estate, joint ownership, and payable or transfer on death designations may be able to avoid probate. A will does not avoid probate as it is designed to go through the probate process. Speak to a professional today. A will is just one way to pass along your house. Joint ownership and revocable living trusts allow you to pass along your home, live in it while you're alive, and make sure your assets go where you want them to. Joint ownership and revocable living trusts are not necessarily replacements for a will. You should still create a will as a backup to carry out final wishes and pass along any other property that isn't in a trust or other probate avoidance. What is joint ownership? If you and your spouse or anyone else jointly own a house and the right of survivorship is included in that ownership, the house will automatically pass to the other individual upon your death without probate. Your spouse will be required to file paperwork to claim ownership. Wisconsin offers two types of joint ownership. Number 1, joint ownership, where 2 or more parties own an equal share. This works well for couples who acquire property together and each owns a half interest. However, this will not avoid probate for the remaining party, or if the 2 parties were to die simultaneously. Number 2, survivorship marital property, known in other states as community property, where the surviving spouse inherits any joint property. This does not include any property that's not part of the marital estate, such as anything kept as separate property. What does using a revocable trust mean? A revocable living trust is created while you're alive and revocable because you can make changes as you wish as long as you're able to. This written document can be used for your house as well as other assets, such as bank accounts, other real estate, and vehicles. A minimum of 3 parties participate in a trust. The settlor or grantor who creates the trust, your spouse may also be a trustee. The trustee, the person or persons who accept the property from the trust and manage it according to the trust. That's you while you're alive, and whomever you assign after you die. You can have multiple co-trustees if you like. Beneficiaries are the individuals who receive income from the trust's property, and if directed, the property as well. There are advantages and disadvantages to both options. Joint ownerships and trusts are available to anyone but aren't a one-size-fits-all option. An experienced estate planning attorney who understands both can help you decide which one is right for your specific circumstances. Contact Heritage Law Office today for a free case evaluation. Here's how to avoid probate. If you pass away without proper pre-planning, your assets will likely go through probate. Probate is a court-supervised process for distributing your assets to your heirs. The process can be time-consuming and expensive, and it can tie up your assets for months or even years. What is probate? Probate is the legal process of distributing a deceased person's assets to their heirs. If the deceased person had a will, the court will follow the instructions in the will. If the deceased person did not have a will, the court will distribute the assets according to state law. The probate process can be time-consuming and expensive. It can also be stressful for the family members who are trying to settle the estate. The probate process can take months or even years to complete, and during that time, the assets of the estate are usually not available to the heirs. Why you should plan your estate to avoid probate. There are several good reasons to plan your estate to avoid probate. The probate process can be expensive. Probate can tie up your assets for a significant period of time. Probate is a public process, which means that anyone can access the documents filed with the court. If you don't want your assets to go through probate, you need to plan your estate carefully. There are several ways to avoid probate, including setting up a trust, transferring ownership of your assets to a beneficiary, or giving your assets away. How can you avoid probate? If you plan your estate carefully and properly, you can avoid probate altogether. One way to avoid probate is to create a trust. A trust is an arrangement in which property is held by one person, the trustee, for the benefit of another person, the beneficiary. Trusts can be used to avoid probate because the property in the trust does not go through probate when the trustor dies. Another way to avoid probate is to name a payable on death (POD) or transfer on death (TOD) beneficiary on eligible accounts. Assets that have a payable on death or transfer on death designee will not go through the probate process. Another way to avoid probate is to give away property during your lifetime. For example, you could give your assets to your children now instead of waiting until after you die. However, this may not be practical for everyone and may not have the best tax consequences for your children. Allowing your children to inherit assets allows them to benefit from a step-up in cost basis. Finally, some other estate planning tools, such as a life estate, may be available to avoid probate. There are many estate planning tools, each with their own uses. It is important to speak with an experienced estate planning attorney to find the proper tool for your individual situation. Thank you for watching this video brought to you by Heritage Law Office. If you found this information valuable and wish to learn more, don't forget to like, share, and subscribe to our channel for more insightful content. In this video, we will discuss how to amend a living trust, including the reasons for making amendments and the steps involved in the process. A living trust, also known as a revocable trust, is a legal document created during a person's lifetime that designates a trustee to manage the individual's assets for the benefit of the beneficiaries. One of the main advantages of a living trust is that it allows for the easy transfer of assets without the need for probate. There are several common reasons why you might need to amend a living trust. You may need to add or remove beneficiaries due to marriage, birth of children, or death. You might want to appoint a new trustee or successor trustee. Perhaps you need to modify how the assets are distributed among beneficiaries. Or you could be adding newly acquired assets to the trust. Changes in personal circumstances, such as marital status, financial status, or health conditions, can also necessitate amendments. To amend a living trust, follow these steps. First, review your original living trust document to understand its provisions and identify the sections that need changes. Next, decide on the type of amendment. There are two primary methods: a trust amendment for minor changes or a restatement of the entire trust for major changes or multiple amendments. Then, draft the amendment. Clearly title the document as an amendment to the living trust, specify the date of the original trust and the date of the amendment, detail the specific changes being made, and include a clause reaffirming the unchanged portions of the trust. Sign and notarize the amendment. Both the grantor and the trustee, if different from the grantor, should sign the document in the presence of a notary public. Attach the amendment to the original trust document to ensure all parts of the trust are easily accessible and legally recognized. Finally, notify all relevant parties, including trustees, beneficiaries, and financial institutions, of the changes to the trust. When amending a living trust, it's important to maintain consistency in the document to avoid any confusion and potential legal disputes. Consider how the amendment might affect your estate taxes and consult with a tax advisor if necessary. If you amend your living trust, you may also need to update related estate planning documents such as wills, powers of attorney, and beneficiary designations. When changing successor trustees, choose someone you trust to manage your assets responsibly. In summary, amending a living trust involves reviewing the document, deciding on the type of amendment, drafting the changes, signing and notarizing, attaching the amendment to the original trust, and notifying relevant parties. While it's possible to amend a living trust on your own, consulting with an experienced attorney is highly recommended to ensure that the amendments are legally valid and correctly executed. An attorney can provide guidance tailored to your specific situation and help avoid common pitfalls.
Welcome! Today, we're starting a comprehensive series on estate planning specifically for business owners. In this first video, we'll cover why estate planning is crucial for anyone who owns a business and set the stage for the topics we'll delve into throughout this series. As a business owner, you've likely invested significant time, effort, and resources into building your enterprise. Estate planning ensures that all your hard work is protected and your business continues to thrive, even when you're no longer at the helm. So, what exactly is estate planning for business owners? It's the process of arranging your affairs to ensure your business and personal assets are managed and transferred according to your wishes after your death or in the event of your incapacitation. This planning helps minimize potential disputes, taxes, and other complications that could arise. One key aspect of estate planning is succession planning. This involves identifying who will take over your business when you're no longer able to run it. Whether it's a family member, a key employee, or a third-party buyer, having a clear succession plan ensures a smooth transition and continuity of operations. Another critical component is asset protection. Estate planning strategies can help protect your business assets from creditors, lawsuits, and other potential risks. This is especially important for business owners, as your personal and business assets are often intertwined. Tax planning is also a significant part of estate planning. Effective tax strategies can help reduce the tax burden on your estate, ensuring more of your hard-earned wealth is passed on to your heirs or reinvested in your business. Throughout this series, we'll explore various tools and strategies you can use in your estate planning, including wills, trusts, buy-sell agreements, and more. We'll also cover important topics like valuing your business, funding succession plans, and addressing potential conflicts among heirs or business partners. By the end of this series, you'll have a comprehensive understanding of estate planning for business owners and be well equipped to start or refine your own plan. Remember, estate planning isn't a one-time task. It's an ongoing process that should be reviewed and updated regularly to reflect changes in your business and personal life. Working with a qualified attorney and financial advisor is crucial to ensure your plan is legally sound and effectively meets your goals. Thank you for joining us in this series. Stay tuned for our next video, where we'll dive into the basics of business succession planning and why it's vital for your business's future. If you have any questions or need personalized advice, consult with a qualified estate planning attorney. See you in the next video. In our last video, we discussed funeral trusts and spend-down strategies for nursing home care and Medicaid eligibility. Today, we're going to explore an important aspect of Medicaid planning, the look-back period and potential penalties. When you apply for Medicaid, there's a financial review process called the look-back period. This is a span of 5 years during which Medicaid examines your financial transactions to ensure you haven't transferred assets solely to qualify for Medicaid. The purpose is to prevent people from giving away their money or property just to meet Medicaid's asset limits. During this 5-year window, Medicaid looks at any gifts, transfers, or sales of assets you've made. If they find that you've transferred assets for less than fair market value, these transactions may trigger penalties. For example, if you gifted a significant amount of money to a family member within the look-back period, Medicaid may impose a penalty period during which you are ineligible for benefits. Penalties for violating the look-back period rules involve a waiting time before you can receive Medicaid coverage. The length of this period depends on the amount of money or value of assets transferred. Medicaid calculates how long the amount transferred would have paid for your care, and that duration becomes your penalty period. So, how can you avoid these penalties? First, early planning is crucial. Start planning for long-term care and Medicaid well before you need it. This gives you time to arrange your finances in a way that complies with Medicaid rules. Second, be aware of the types of transactions that can trigger penalties. Large gifts, property transfers, and sales for less than market value within the look-back period can all lead to penalties. It's essential to document any transactions and understand their potential implications. Third, consider working with a qualified attorney who has experience in elder law and Medicaid planning. They can help you navigate the complex rules and develop a strategy that minimizes penalties while protecting your assets. Let's look at a couple of real-life examples. Imagine someone who transferred a large sum of money to their children 2 years before applying for Medicaid. This transfer would likely trigger a penalty period, delaying their eligibility for Medicaid benefits. On the other hand, someone who planned ahead and set up an irrevocable funeral trust 5 years in advance would have those funds exempt from the look-back review, avoiding penalties. Even if you haven't planned 5 years in advance, there are still ways to protect some of your funds. Consulting with an experienced attorney can help you explore options like partial asset protection and other strategies tailored to your specific situation. In summary, understanding the Medicaid look-back period and its penalties is vital for effective Medicaid planning. By starting early, avoiding questionable transactions, and seeking professional guidance, you can protect your assets and ensure you're prepared for future long-term care needs. Thank you for watching. If you have more questions or need personalized advice on Medicaid planning and the look-back period, consult with a qualified attorney to explore your options.
For less than the cost of 1 month in a nursing home, this strategy can protect your entire life savings. The cost of nursing home care can be overwhelming, often exceeding $9,000 per month. Medicaid rules require that your assets fall below a certain limit before you can qualify for free nursing home care. This asset limit is often shockingly low, $2,000 in many states. This means you'll have to deplete your entire life savings before you can receive assistance. However, there is a solution: an irrevocable trust. By creating an irrevocable trust and transferring your assets into that trust, you can set aside and protect assets and qualify for Medicaid. When you transfer your assets into an irrevocable trust, the assets are no longer considered yours. The trust owns the assets. This means if you transfer your assets into this trust and you fall within the Medicaid eligibility limits, you can qualify for Medicaid without spending down your life savings. By using this strategy, you can qualify for free nursing home care while your assets in the irrevocable trust are protected and set aside for your loved ones. However, it's important to note the 5-year look-back period. Medicaid reviews your financial transactions for the past 5 years, and any transfers made during this period could result in an ineligibility period. Assets transferred longer than 5 years ago do not affect your eligibility. If you expect to require nursing home care within 5 years, you can still benefit from this type of estate planning, but the results are much more limited than if you planned at least 5 years ahead. Therefore, planning ahead is crucial. Start planning today to protect your hard-earned assets.
Imagine you're one of the highest paid people on the planet, making $1,000 an hour. Sounds amazing, right? But let's see how far that really gets you. You work 10 hours a day, raking in $10,000 daily. Do that every day for a year, and you've made about $3.65 million. But wait, let's stretch this out. If you keep this insane pace for 40 years, you'll make around $146 million before taxes. But here comes the tax man. Assuming 40% goes to taxes, you're left with roughly $87 million after 4 decades of hard work. Here's the kicker. You work at 10 hours every single day for 40 years. And after all that, you'd still only have about 8.7% of $1 billion. Not even close to billionaire status. Remember, it's not just about how much you earn, it's about how much you keep. The wealthiest rely on smart tax planning and strategies to protect their legacy. So next time you hear about billionaires, remember, even if you made $1,000 an hour for decades, you'd barely make a dent. Billionaire money is about ownership, leverage, and scaling wealth beyond any salary.
In this video, we will explore the benefits and process of buying property through a trust. A trust is a legal arrangement where one party, known as the trustee, holds property for the benefit of another party, known as the beneficiary. Trusts can be used for various purposes, including estate planning, asset protection, and privacy. One of the main benefits of buying property through a trust is asset protection. Properties held in a trust can be shielded from creditors' claims and lawsuits. Additionally, trusts offer privacy by keeping ownership details out of public records. When it comes to estate planning, trusts allow for the efficient transfer of assets upon the owner's death, avoiding the lengthy and costly probate process. Trusts also provide control over how and when assets are distributed to beneficiaries. Properly structured trusts can offer significant tax benefits, reducing estate taxes and providing other tax advantages. Several types of trusts can be used for buying property. A revocable trust allows the grantor to retain control and make changes to the trust. This type of trust is ideal for estate planning and can simplify the transfer of property after death. An irrevocable trust, once established, cannot be altered or revoked. This type of trust provides stronger asset protection and potential tax benefits. Charitable trusts allow property owners to support charitable causes while receiving tax benefits. Special needs trusts are designed to provide for beneficiaries with special needs without affecting their eligibility for government benefits. Now, let's go through the steps to buy property through a trust. First, establish the trust with the help of an experienced attorney. This involves drafting the trust document and naming the trustee and beneficiaries. Next, find a suitable property that aligns with your investment goals and the terms of the trust. If financing is needed, work with lenders who are familiar with lending to trusts. Ensure the property is titled in the name of the trust, not the individual, to maintain the legal protections and benefits of the trust structure. Once the property is purchased, the trustee will manage it according to the trust terms, ensuring that all obligations, such as taxes and maintenance, are met. Trustee duties include managing trust assets, maintaining the property, keeping up with property taxes and insurance, and acting in the best interests of the beneficiaries. Trustees must also keep detailed records and provide regular reports to the beneficiaries. Beneficiaries have the right to access trust documents, receive regular updates, and receive distributions as specified in the trust document. They must comply with the terms and conditions outlined in the trust and stay informed about the trust's activities. Key considerations for buying property through a trust include understanding the legal and tax implications. Trust laws can vary by state, so it's important to ensure compliance with local regulations. Engage an experienced attorney to navigate the complexities of setting up and managing a trust. Practical steps for trust management include regular property inspections, creating a budget for property expenses, and developing a prudent investment strategy for any income generated by the property. In summary, buying property through a trust offers significant benefits, including asset protection, privacy, estate planning advantages, and tax benefits. However, it requires careful planning and management. Consider seeking professional advice to ensure your real estate investments are secure, efficiently managed, and aligned with your long-term goals.
Estate planning sounds like paperwork for living. Fewer surprises, fewer delays, less stress. One of the biggest hidden benefits is emotional. Fewer family blow-ups. When plans are unclear, people fill the gaps with assumptions, and grief amplifies everything. A good plan spells out decisions, roles, and timing, so your loved ones aren't negotiating under stress. Another benefit people rarely talk about: privacy. In many places, once probate is filed, a will can become part of the public record. With trust-based planning and good beneficiary setup, you can often keep sensitive details, like who gets what and when, out of the spotlight. Speed matters. Probate timelines vary, but it's common for the process to take many months. When key assets are set up with beneficiary designations, transfer on death options, or properly funded trusts, your family may be able to access resources sooner, often with fewer fees and fewer court steps. Here's the part most people miss. Estate planning is also incapacity planning. If you can't speak or sign, who pays bills, manages accounts, and makes health decisions? A power of attorney and advanced healthcare directives help your family act with confidence without guessing. If you have kids or people who rely on you, this is huge. Estate planning can name guardians, set backups, and create a structure for managing funds responsibly. It's one of the few ways to turn "I hope" into "I decided." If you own a business, estate planning isn't optional. It's continuity planning. The plan can define who has authority, how partners are bought out, and what happens if you're unavailable. Done well, it protects employees, customers, and the people who depend on that income. Your estate isn't just your house and accounts. It's also your digital life, passwords, photos, subscriptions, even crypto or online businesses. A plan can name who handles digital assets and where your instructions live, so accounts aren't lost or locked forever. Estate planning can be values planning. Beyond dollars, you can support causes, tell family stories, and create guardrails that reflect what you cared about. Even a simple letter, kept with your plan, can reduce misunderstandings and help your family honor your intentions. To get value fast, start small. First, make an inventory of major assets and accounts. Second, choose the people, who decides and who backs them up. Third, take one next step and book an appointment, bringing your list. And a quick note: this is educational, not legal advice. Rules vary, so work with a qualified professional for your situation.
When someone close to you passes away, dealing with their estate through probate can feel like navigating a maze while you're still grieving. But here's the thing most people don't realize. Probate doesn't have medical concepts either. I'm talking about real strategies that have saved my clients thousands of dollars and months of frustration. By the end of this video, you'll know exactly what to expect and how to avoid the most common pitfalls that trip up 90% of families going through probate. Key number 1 is frame. Inventories to be filed on schedule, and final distributions to happen according to their calendar, not yours. I always tell my clients to think of probate like a chess game where every move has consequences, and timing is everything. Key number 2 revolves around proper documentation and organization. Here's where most families stumble badly. They'll spend weeks searching for a single document that should have been organized from day one. Create a master file system immediately. Bank statements, insurance policies, property deeds, tax returns from the past 3 years, and any business documents need to be categorized and accessible. I've seen probate cases drag on for years simply because someone couldn't locate a critical piece of paperwork when the court demanded it. Key number 3 is managing family dynamics and communication. This one might surprise you, but family conflict is the #1 reason probate cases turn ugly and expensive. Even the most loving families can fall apart when money and property are involved. Set up regular family meetings, keep everyone informed about the process, and establish clear boundaries about decision-making authority. Remember, the executor has legal responsibilities that sometimes require making unpopular decisions, and that's okay. Key number 4 focuses on working with the right professionals. Trying to handle probate alone is like performing surgery on yourself. You might save money up front, but the mistakes will cost you far more in the long run. A qualified probate attorney isn't an expense. They're an investment in getting things done correctly the first time. Look for someone who has experience in probate, not just general practice law. Ask about their typical timeline for cases like yours, and make sure they explain everything in terms you can understand. Key number 5 is protecting estate assets throughout the process. This means securing property, maintaining insurance coverage, and making smart decisions about when to sell assets versus when to hold on to them. Market timing can make a significant difference in the final value of an estate, and understanding tax implications before you act can save thousands. The probate process doesn't have to define this chapter of your family's story. With proper preparation, clear communication, and the right professional guidance, you can honor your loved one's memory while protecting what they worked so hard to build. These 5 keys have helped hundreds navigate probate.
The role of life insurance on estate planning for business owners. In our previous videos, we've explored various aspects of business succession planning. Today, we're going to focus on the role of life insurance in succession planning and how it can be a valuable tool in ensuring the smooth transition of your business. Life insurance can play a critical role in business succession planning by providing the necessary funds to address financial needs that arise upon the death of a business owner. Let's look at some specific ways life insurance can be used in your succession plan. First, let's talk about buy-sell agreements. A buy-sell agreement is a legally binding contract that outlines how a partner's share of the business will be handled if they pass away, become disabled, or decide to leave the business. Life insurance can be used to fund these agreements. For example, if you and your business partners each take out a life insurance policy on each other, the proceeds from the policy can be used to buy out the deceased partner's share of the business. This ensures that the business remains in the hands of the surviving owners and provides financial support to the deceased partner's family. Second, life insurance can provide liquidity to pay estate taxes. For many business owners, a significant portion of their wealth is tied up in the business. When they pass away, their heirs may face substantial estate taxes. If there aren't enough liquid assets to cover these taxes, the business might have to be sold or liquidated to pay the tax bill. Life insurance proceeds can provide the necessary funds to pay estate taxes, allowing the business to continue operating without disruption. Third, life insurance can be used to equalize inheritances. If you have multiple heirs, but not all of them are involved in the business, life insurance can help ensure that each heir receives a fair share of your estate. For example, you can leave the business to the heirs who are involved in its operations and use life insurance proceeds to provide an equivalent value to the heirs who are not involved. This can help prevent conflicts and ensure that all your heirs are treated fairly. Another important use of life insurance is in key person insurance. Key person insurance is a policy taken out by a business on the life of an essential employee, such as an owner or top executive. The business is the beneficiary of the policy, and the proceeds can be used to cover the financial loss that occurs when a key person dies. This can include costs related to finding and training a replacement, lost revenue, and reassuring creditors and customers that the business will continue to operate smoothly. When considering life insurance for succession planning, there are several types of policies to choose from. Term life insurance provides coverage for a specific period, making it a cost-effective option for temporary needs. Whole life insurance, on the other hand, provides permanent coverage and builds cash value over time, which can be used for other financial needs. Universal life insurance offers flexibility in premium payments and death benefits, allowing you to adjust the policy as your needs change. It's essential to work with a qualified insurance advisor and estate planning attorney to determine the best type and amount of life insurance for your situation. They can help you understand the options available and ensure that the policies align with your overall succession plan. In summary, life insurance is a versatile and valuable tool in business succession planning. It can provide the funds needed to buy out a deceased partner's share, pay estate taxes, equalize inheritances, and cover the financial loss of a key person. By incorporating life insurance into your succession plan, you can ensure the continuity and stability of your business for the future. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified estate planning attorney. See you. Welcome to our series on starting a business. Today, we're going to discuss the key legal steps you need to take when starting a new business. Understanding these legal considerations is crucial for ensuring your business operates smoothly and is set up for success. First, let's talk about choosing the right business structure. The most common structures are sole proprietorship, partnership, limited liability company, or LLC, and corporation. Each structure has different implications for liability, taxes, and management. A sole proprietorship is the simplest form but doesn't provide personal liability protection. An LLC offers liability protection and flexible tax options, making it a popular choice for small businesses. Corporations provide the most liability protection but come with more regulatory requirements. Next, you need to register your business. This involves choosing and registering your business name, often called a DBA, or doing business as. You'll need to file the necessary paperwork with your state and local authorities. Obtaining the necessary licenses and permits is another key step. The requirements vary depending on your business type and location. For example, a restaurant may need health permits, while a construction company may need specific contractor licenses. Research the licenses and permits required for your business and apply for them before you start operating. Understanding your tax obligations is essential. Start by obtaining an Employer Identification Number, or EIN, from the IRS. This number is used for tax filings and other business activities. You should also understand your obligations for sales tax, payroll tax, and income tax. Consulting with a tax advisor can help ensure you meet all your tax responsibilities. Creating a business plan is both a strategic tool and a legal consideration. A comprehensive business plan includes an executive summary, market analysis, and financial projections. It helps guide your business decisions and can be crucial for securing financing. Setting up your business finances is important. Open a business bank account to keep your personal and business finances separate. Set up accounting and bookkeeping systems to track your income and expenses accurately. Understanding your business insurance options is also important. Insurance can protect your business from various risks, such as liability claims and property damage. Employment law considerations are crucial if you plan to hire employees. Understand the difference between hiring employees and independent contractors. Comply with employment laws regarding wages, benefits, and workplace safety. Creating employment contracts and an employee handbook can help outline expectations and legal requirements. Protecting your intellectual property is vital. This includes trademarks, copyrights, and patents. Register your intellectual property to prevent others from using your brand or products without permission. Drafting key contracts and agreements is essential for legally binding business relationships. This includes partnership agreements, client contracts, and supplier agreements. Having clear, written agreements helps prevent disputes and outlines each party's responsibilities. Compliance with industry regulations is critical. Each industry has specific regulations that businesses must follow. Ensure you understand and comply with these regulations to avoid legal issues. Seeking professional advice is highly recommended. Consulting with legal, financial, and business advisors can help ensure you're taking the right steps. In conclusion, starting a business involves several key legal steps: choosing the right business structure, registering your business, obtaining necessary licenses, understanding tax obligations, creating a business plan, setting up finances, complying with employment laws, protecting intellectual property, drafting key contracts, and ensuring industry compliance. Taking these steps will help you build a solid legal foundation for your business. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified attorney or business advisor. See you.
Your home is paid off. Your retirement accounts are healthy. You're living the American dream. Then it happens. A stroke. A fall. Alzheimer's creeping in like fog over a harbor. Suddenly, you need round-the-clock care and the bill. Try $120,000 a year, every single year. That's $10,000 a month disappearing from everything you've built. Within 3 years, your life savings are gone. Your spouse is left scrambling, potentially facing poverty after a lifetime of financial responsibility. Your children watch helplessly as their inheritance, meant to secure their own retirements, evaporates into the healthcare system. This isn't a nightmare scenario. This is Tuesday afternoon in America for thousands of families. The truth is, nursing home costs aren't just expensive. They're catastrophic. We're talking about an industry that has turned elder care into a wealth extraction machine. And here's the kicker. Medicare covers almost nothing. Medicaid will help, but only after you've spent down nearly every asset you own. You're essentially required to become impoverished before the safety net kicks in. But what if I told you there are completely legal strategies that savvy families use to protect their assets while still qualifying for benefits? What if there were ways to ensure your spouse doesn't end up destitute, and your children aren't forced to choose between their own financial security and your care? Today, I'm going to walk you through the exact methods that estate planning attorneys use for their own families. The strategies that the wealthy have been quietly employing for decades while middle-class America gets financially decimated by long-term care costs. We'll explore everything from the 5-year look-back period to sophisticated trust structures that can shield millions in assets. This isn't about gaming the system or committing fraud. These are legitimate, court-tested strategies that Congress specifically allows because they recognize that impoverishing families shouldn't be the price of growing old in America. Let's start with the brutal mathematics of nursing home costs, because understanding the scope of this threat is crucial to appreciating why asset protection isn't just smart, it's essential. The average cost of a private room in a nursing home has skyrocketed to over $120,000 annually. In high-cost areas like New York or California, you're looking at $150,000 to $200,000 per year. That's more than most people's entire annual income, and it's due every month regardless of the quality of care. Memory care facilities, which many Alzheimer's patients require, can cost even more. We're talking $180,000 to $250,000 annually for specialized dementia care. And here's what really stings. The average nursing home stay is 2.4 years, but that's just an average. 20% of residents stay 5 years or longer. Some families face a decade or more of these crushing expenses. Do the math. Even at the national average, a 3-year stay costs $360,000. A 5-year stay? $600,000. These numbers aren't theoretical. They're the financial reality facing 1.3 million Americans currently living in nursing homes, with 10,000 baby boomers turning 65 every single day. Medicare, the program most people assume will cover their long-term care, provides virtually no help. It covers skilled nursing care for a maximum of 100 days, and only if you meet strict criteria about being hospitalized first and requiring skilled medical care, not just custodial care. Most nursing home residents need custodial care, help with bathing, dressing, eating, basic daily activities. Medicare doesn't cover that at all. So families face a choice. Pay out of pocket until you're broke, or spend down your assets to qualify for Medicaid. This spend-down process is where most families make critical mistakes that cost them hundreds of thousands of dollars unnecessarily. Medicaid will cover nursing home costs, but there's a catch. You can only keep $2,000 in countable assets. Your house might be protected while you're alive, but Medicaid has the right to recover costs from your estate after death. Your retirement accounts, your savings, your investments, all of it must be liquidated to pay for care before Medicaid steps in. For married couples, the rules are slightly more generous, but still devastating. The community spouse, the one still living at home, can keep approximately $150,000 in assets, and monthly income of around $3,800. Everything above those limits must be spent on the nursing home spouse's care. Imagine working for 40 years, building a $800,000 nest egg, only to watch $650,000 of it disappear into nursing home payments. But here's where it gets interesting. Medicaid has what's called a 5-year look-back period. Any gifts or asset transfers made within 5 years of applying for benefits are scrutinized. Make an improper transfer, and you face a penalty period where you're ineligible for benefits. This is where most families panic and make expensive mistakes. However, and this is crucial, there are numerous exceptions and strategies that allow for proper asset protection even within this look-back period. The key is understanding what Medicaid considers a legitimate transfer versus what triggers penalties. Transfers to certain types of trusts, purchases of exempt assets, and specific gifting strategies can all be done legally and effectively. The wealthy figured this out long ago. They don't lose sleep over nursing home costs because their estate planning attorneys have structured their assets properly. They use irrevocable trusts, strategic gifting programs, and asset repositioning techniques that keep their wealth protected while still qualifying for benefits when needed. The middle class, meanwhile, typically gets advice that sounds something like this. Well, you'll just have to spend down your assets until you qualify for Medicaid. That's not advice. That's surrender. And it's completely unnecessary if you understand the rules and plan accordingly. What we're about to explore are the specific strategies that can protect your assets legally and ethically. From simple techniques that anyone can implement to sophisticated trust structures for larger estates, there are options available at every wealth level. The key is understanding the rules, timing your moves correctly, and avoiding the common pitfalls that trap unprepared families. Because here's the truth they don't want you to know. Asset protection from nursing home costs isn't about being wealthy. It's about being informed. The first and most accessible strategy in your asset protection toolkit is understanding exempt assets. These are resources that Medicaid simply cannot touch, regardless of their value. Your primary residence is an example of an exempt asset, protected in most states. But here's what most people don't realize. You can actually increase this protection by making strategic home improvements or paying down your mortgage with countable assets. Think about it. If you have $100,000 sitting in a savings account, that's a countable asset that must be spent down. But if you use that same money to renovate your kitchen, add a bathroom, or install a new roof, you've just converted countable assets into exempt assets. The value is still there. It's just protected now. This isn't hiding money. This is smart repositioning. Your car is another exempt asset, but only one vehicle per household. Families have legitimately purchased $80,000 luxury vehicles or specially equipped vans and had them considered exempt assets. Again, you're not losing the value. You're converting it into a protected form. However, after you pass away, Medicaid will attempt to recover assets from your estate for any expenses they paid on your behalf. This means they may be able to recover your house or car. To solve this, let's move beyond basic exempt assets and talk about more sophisticated strategies. The irrevocable trust is perhaps the most powerful tool in the asset protection arsenal. When properly structured, these trusts can protect unlimited assets from nursing home costs while still providing some benefits to the person who created them. Here's how it works. You transfer assets into an irrevocable trust, typically naming your children or other beneficiaries as the ultimate recipients. The trust is structured so that you retain certain limited rights, perhaps the right to live in your home if it's transferred to the trust, or the right to receive income from investments held by the trust. The key is that you no longer own these assets outright, so they're not counted for Medicaid purposes. The catch? This strategy requires advanced planning. Remember that 5-year look-back period. Any assets transferred to an irrevocable trust must be done at least 5 years before applying for Medicaid benefits. That's why this isn't a crisis planning technique. It's a long-term strategy that requires foresight and commitment. But what if you're already facing an immediate need for long-term care? What if that 5-year window has closed? Don't despair. There are still powerful strategies available, though they require more sophisticated planning and often professional guidance. The Medicaid-compliant annuity is one such technique. By converting countable assets into an income stream through a specially structured annuity, you can often protect significant wealth while still qualifying for benefits. The annuity must meet specific requirements. It must be immediate, irrevocable, and actuarially sound. But when done correctly, it can preserve hundreds of thousands of dollars. For married couples, the strategies become even more nuanced and powerful. The Community Spouse Resource Allowance allows the at-home spouse to retain approximately $150,000 in assets. But through a technique called spousal refusal, the community spouse can actually refuse to contribute their assets to the nursing home spouse's care. This creates a fascinating dynamic where the nursing home spouse can qualify for Medicaid while the community spouse retains significantly more assets. Asset purchase strategies offer another avenue for protection. Instead of simply spending down assets on nursing home care, families can purchase items that are either exempt or provide ongoing value. Prepaying funeral expenses, buying a more expensive home in a state with higher homestead exemptions, or purchasing certain types of life insurance can all serve as effective spend-down strategies that preserve value for the family. The key to all of these strategies is understanding that Medicaid planning isn't about impoverishment. It's about reorganization. You're not making assets disappear. You're restructuring them in ways that comply with Medicaid rules while still providing maximum benefit to your family. Geographic arbitrage plays a role too. Some states are far more generous in their Medicaid rules than others. The homestead exemption varies dramatically by state. Income and asset limits differ. Even the rules around trust protection vary significantly. Families sometimes relocate strategically to take advantage of more favorable Medicaid rules in their new state of residence. But perhaps the most overlooked strategy is the proper use of caregiver agreements. When adult children provide care for aging parents, this care has real economic value. A properly structured caregiver agreement allows families to compensate adult children for this care, effectively transferring assets while receiving legitimate services in return. The key is documenting the arrangement properly and ensuring the compensation is reasonable for the services provided. Finally, these strategies can often be used together to create a plan that works for your situation. The mistake most families make is waiting until crisis hits before exploring these options. By then, many of the most powerful strategies are no longer available. The 5-year look-back period means that effective asset protection requires the kind of advanced planning that most people resist because it forces them to confront uncomfortable realities about aging and long-term care. While you can still protect a portion of your assets if there was no plan when a crisis hit, planning ahead at least 5 years gives you the biggest opportunity to protect the most amount of assets. This is where the wealthy have always had an advantage. They plan early, they plan comprehensively, and they work with professionals who understand these complex rules. But these strategies aren't reserved for the ultra-rich. Middle-class families can implement many of these same techniques with proper guidance and sufficient lead time. The question isn't whether you'll face long-term care costs. The statistics are clear. Most of us will need some form of extended care before we die. The question is whether you'll face those costs with a plan that protects your family's financial security, or whether you'll join the millions of Americans who watch their life savings disappear into the healthcare system. So there you have it. The roadmap that separates families who preserve their wealth from those who watch it vanish into the nursing home abyss. From exempt asset strategies and irrevocable trusts to caregiver agreements and geographic planning, these aren't just theoretical concepts. They're the actual tools that informed families use to navigate the brutal mathematics of long-term care without sacrificing everything they've built. Remember, this isn't about gaming the system. It's about understanding rules that were specifically designed to prevent the complete impoverishment of American families. The wealthy have been using these strategies for decades, while middle-class America gets steamrolled by costs they never saw coming. The clock is ticking on your planning window. Every day you wait is another day closer to that 5-year look-back period that could lock you out of your best options. Don't be the family that discovers these strategies exist only after it's too late to implement them. Your life savings don't have to become a casualty of growing old in America. With proper planning, the right strategies, and sufficient lead time, you can protect what you've built while still ensuring quality care when you need it. The choice is yours, but the time to make it is now. Thanks for joining me today. If this opened your eyes to possibilities you didn't know existed, share it with someone who needs to hear this message. Because in the end, financial security in retirement isn't about luck. It's about knowledge, and knowledge shared is power multiplied.
Welcome back to our series on estate planning for business owners. In our last video, we introduced the importance of estate planning for your business. Today, we're going to focus on a critical component of that process, business succession planning. So, what exactly is business succession planning? Simply put, it's the process of preparing for the transfer of your business ownership and management to someone else when you retire, become incapacitated, or pass away. This plan ensures that your business can continue to operate smoothly and successfully, regardless of what the future holds. Business succession planning involves several key steps. Let's break them down. First, identify potential successors. This could be a family member, a key employee, a business partner, or even an outside buyer. The right choice depends on your business structure, your family situation, and your personal wishes. It's important to evaluate the skills, experience, and readiness of potential successors to ensure they can effectively take over the business. Second, develop a formal succession plan. This plan should outline the process for transferring ownership and management of the business. It includes legal documents such as buy-sell agreements that detail how the transfer will occur and under what conditions. The plan should also address the financial aspects of the transition, such as business valuation, funding mechanisms, and tax considerations. Third, prepare your successor. This involves training and mentoring the chosen individual to ensure they have the necessary knowledge and skills to lead the business. Gradually increasing their responsibilities can help them gain confidence and experience. This step is crucial to maintaining continuity and preserving the business's value. Fourth, communicate your plan. It's important to share your succession plan with key stakeholders, including family members, employees, business partners, and advisors. Open communication helps prevent misunderstandings and conflicts, ensuring everyone is on the same page regarding the future of the business. Why is business succession planning so important? Without a solid plan in place, the transition of your business can be chaotic and disruptive. It can lead to conflicts among family members or business partners, loss of key employees, and a decline in business value. A well-thought-out succession plan, on the other hand, provides stability and continuity, protecting your business's legacy and ensuring its ongoing success. Succession planning also has significant financial implications. Proper planning can help minimize taxes and other costs associated with the transfer of ownership. It can also ensure that your retirement is financially secure and that your heirs receive their fair share of the business's value. In summary, business succession planning is about preparing for the future and ensuring your business can thrive without you. It involves identifying potential successors, developing a formal plan, preparing your successor, and communicating the plan to all relevant parties. Thank you for watching. In our next video, we'll dive into the steps for creating a robust business succession plan. If you have any questions or need personalized advice, consult with a qualified estate planning attorney. See you in the next video.
How to save over $100,000 through Medicaid planning. Nursing home costs are expensive and add up quickly. Within a short period of time, an entire life savings can be depleted by paying for the cost of a stay in a nursing home. With proper planning, however, substantial value may be able to be preserved and passed along. Here is an example of how to save over $100,000 through active Medicaid planning. Mary has a savings account worth $75,000 and an investment account worth $150,000, totaling $225,000. Mary will be requiring nursing home care starting next month. Nursing home expenses are $10,000 per month. Since Mary did not previously buy long-term care insurance or pre-plan, Mary will have to cover the costs out of pocket. Mary will have to pay out of the savings account and liquidate the investment account to pay for nursing care. In less than 2 years, Mary will be completely out of money. Medicaid is administered by states according to federal requirements. State rules may vary. For example, in Wisconsin, the Medicaid rules are structured so that once you have less than $2,000 in assets, Medicaid will pay for a required nursing home stay. Now that Mary has spent $225,000 and is out of money, public benefits will pay for Mary's nursing home care. Most people struggle with the concept of seeing their entire life savings depleted very quickly. They would prefer to transfer those assets to their children, family members, friends, or donate that money to charity, rather than seeing the money depleted. The easy solution seems to be to give away all your assets to drop below the asset limit and qualify for Medicaid. It is not that easy. Medicaid will not allow you to gift away all your assets and immediately qualify for Medicaid benefits. When gifting assets, Medicaid imposes a divestment penalty, causing an ineligibility period for Medicaid, time that must pass before public benefits will pay for nursing home expenses. The larger the value of the gift made, the longer the ineligibility period. The ineligibility period only starts counting down when you apply for Medicaid, and you would be otherwise eligible if the ineligibility period did not exist. At the time of this video, in Wisconsin, for every $303.38 given away, 1 day of Medicaid ineligibility is assessed. If Mary were to give away all her money, then apply for Medicaid, she would be ineligible for 2 years after applying and must find funds to pay for nursing home expenses. Here's one possible way to solve this issue. Again, there are different rules in different states, so be sure you talk to a professional. Mary has a total of $225,000. Mary splits the money into 2 different pieces. One that Mary keeps and turns into a stream of income, and one that Mary gives away to her family, friends, or charity. In this example, Mary converts $118,000 to a stream of monthly income. Income is treated differently than assets and do not count towards the Medicaid asset limit in Wisconsin. Mary receives the money back in equal payments over 12 months as income. We will discuss what Mary does with this cash flow in just a bit. Mary also gives away the remaining $107,000, either to individuals or to a special type of trust, an irrevocable trust. We believe an irrevocable trust is generally a better option for numerous reasons, which we will discuss in a separate video. At this point, Mary has no money remaining. She has gifted $107,000 to family, friends, or a trust, and has spent $118,000 to acquire a monthly income stream. Giving away money is considered a gift, causing a divestment period where Mary is ineligible for Medicaid benefits for a period of time. In Mary's scenario, a gift of $107,000 will cause an ineligibility period of 352 days. Now that Mary has less than $2,000, Mary can apply for Medicaid. Mary will be assessed an ineligibility period due to the $107,000 gift. However, the ineligibility period will now start counting down, and Mary will be eligible for coverage at the end of the 352-day ineligibility period. During the ineligibility period, Mary will use the monthly income stream to pay the nursing home expenses. That stream of income will expire the same time as Mary's ineligibility period, leaving Mary with less than $2,000 during the ineligibility period and when the ineligibility period ends. At the end of the ineligibility period, the income stream will stop, and Medicaid will cover Mary's nursing home expenses. Meanwhile, the assets that are set aside in the trust or gifted to individuals are saved. They are not subject to being spent on nursing home expenses. Rather than spending $225,000 on nursing home expenses and having the entire value of the assets depleted, $107,000 were able to be passed on to friends, family, or charity. Our next video will be about how Mary could have saved almost all of the $225,000 with proper Medicaid pre-planning. Medicaid planning and Medicaid applications are complicated, precise, and vary state to state. One mistake can be very costly. Contact one of our attorneys to make sure your assets are properly protected.
Own rental property. Here's why many investors put rentals in a trust. First, to skip probate. When you pass, property in a revocable living trust can go straight to your beneficiaries, faster, private, and with less cost. Second, to protect your privacy. Title held by a trust keeps your name off public ownership records. Third, for seamless management. If you're incapacitated, a successor trustee can step in to collect rent and handle repairs. What about asset protection? A revocable trust won't shield you from creditors, but some irrevocable trusts can offer protection and help with Medicaid planning. Taxes. With a revocable trust, you keep simple reporting now, and your heirs may receive a step-up in basis at death, reducing capital gains. Have an LLC? Let the trust own the LLC to combine liability protection with estate planning benefits. Got a mortgage? Review the loan and talk to your lender before transferring. Some moves to revocable trusts are allowed under federal law. Think a will is enough? Here's why a living trust might be the smarter move. First, living trusts avoid probate. Unlike a will, a living trust keeps your assets out of court. That means faster transfer to your loved ones and no costly probate fees. Second, living trusts provide privacy. Wills become public record, but trusts stay private. Your family matters, stay your family's business. Third, living trusts have flexibility. It's called living because you can change it any time while you're alive. Update it as life changes. And fourth, living trusts provide continuity. If you become incapacitated, your trustee can step in immediately, with no court delays. Bottom line, a living trust saves time, money, and stress for your family. Want more estate planning information? Hit subscribe.
Welcome to this video explaining Medicaid Asset Protection Trusts, or MAPT. Long-term care costs are substantial, with the national median for a private nursing home room projected at over $127,000 per year by 2026. Families plan early because long-term care can quickly deplete savings. Medicare coverage for long stays is limited, meaning Medicaid often becomes the payer. The goal of planning is to create a structure that helps preserve the home and savings, reducing financial stress. A Medicaid Asset Protection Trust is an irrevocable trust designed to move assets out of your name so they may not count against Medicaid eligibility after the look-back period. You, the grantor, give up direct control of the principal, but the assets may be protected for your beneficiaries. Medicaid eligibility depends on income and countable resources. Assets like bank accounts and second homes are usually countable. However, items like personal belongings and your primary residence, subject to certain equity limits, are often exempt or treated differently. The 5-year look-back period means that when you apply for Medicaid, the state reviews transfers made in the prior 60 months. Transfers without compensation, like gifting cash, can trigger a penalty period. A Medicaid Asset Protection Trust is most effective when created well before care is needed. A Medicaid Asset Protection Trust acts as a legal firewall. You create the trust, fund it by retitling assets, and the look-back clock starts. After 5 years, if properly structured, those trust assets may be treated as non-countable for long-term care Medicaid. For example, if Pat plans 5+ years ahead and moves their home and some savings into a Medicaid Asset Protection Trust, these assets may be shielded if nursing home care is needed later. Without a Medicaid Asset Protection Trust, savings may be quickly spent down. The pros of a Medicaid Asset Protection Trust include protecting your home and preserving savings. However, the key trade-off is that it is irrevocable, meaning you give up access to the trust principal. Transfers made within 5 years may still result in penalties. Common pitfalls include forgetting to fully fund the trust by retitling assets, keeping too much control over the principal, or making changes like selling the home without legal guidance. State rules vary, so always seek tailored advice. For married couples, spousal impoverishment rules protect a portion of the couple's resources and income when one spouse needs care. Federal law also exempts certain transfers of a primary residence from penalty, such as transfers to a spouse or a caregiver child. A high-level checklist for setting up a Medicaid Asset Protection Trust involves clarifying your goals, inventorying assets, choosing trustees, drafting the trust, funding it completely, and creating a maintenance plan to avoid accidental undoing of the plan. For next steps, find an elder law attorney in your state. Be prepared with your asset information and current estate plan. Review your plan annually, as even small changes can affect Medicaid eligibility. Plan early to protect your options.
One way to pass a home to your child or children is to make a will and designate a beneficiary for your home in your newly created will. Although estate recovery issues need to be considered using this method, taxes can generally be reduced or eliminated as individuals receiving property upon the death of another are entitled to an adjustment in the cost basis, a step up when there are built-in gains. Gifting the family house to children has consequences that are often unforeseen by families looking to safeguard their assets. Making such a transfer puts you in a difficult position if your children go through divorce, bankruptcy, incur liability due to a lawsuit, or other financial problem occur that may require reselling the house. If you're planning to move out of the house now, you can give the property to your child. However, attorneys generally have better techniques than making such a transfer. A life estate allows you to transfer part ownership to your children or anyone else while you're alive. You can live in it or rent it out during your lifetime, and when you die, the remaining ownership passes to your kids or others to whom the asset was transferred, who may then take full possession and ownership of the assets. Placing the home in an irrevocable trust with your children as the beneficiaries is another option. Doing so may help you avoid estate taxes, qualify for Medicaid for nursing home or assisted living facility expenses, and protect the house from Medicaid estate recovery. Careful planning is a must, as making a transfer to an irrevocable trust may cause an ineligibility period for Medicaid for a period of time after such a transfer of your home. If the house is eventually sold, the proceeds remain in the trust, and the proceeds of the sale will be passed to the trust beneficiaries. If you gift a piece of real estate directly to your child or grandchild, it is perceived as a gift by the IRS. You cannot claim a loss, nor is your gift tax deductible. Are you unsure whether a will or a trust is the best choice for your estate planning? In this video, we'll explore the key differences between wills and trusts to help you make an informed decision. First, let's talk about wills. A will is a legal document that outlines how you want your assets distributed after your death. It can include instructions for distributing personal property, naming guardians for minor children, and specifying funeral arrangements. One of the main advantages of a will is its simplicity and ease of creation. However, it's important to note that wills must go through the probate process, which can be time-consuming and public. Next, we have trusts. A trust is a fiduciary arrangement that allows a third party or trustee to hold assets on behalf of beneficiaries. There are two main types of trusts, revocable and irrevocable. A revocable trust can be altered or dissolved by the grantor during their lifetime, offering flexibility and control. An irrevocable trust, on the other hand, cannot be easily altered once established, providing greater asset protection and tax benefits. Trusts generally bypass the probate process, offering privacy and potentially faster distribution of assets. When comparing wills and trusts, there are several factors to consider. Cost is one aspect. While wills are generally less expensive to create, trusts can save money in the long run by avoiding probate fees. Flexibility and control also vary, with wills being easier to amend, but trusts offering more control over asset distribution during your lifetime and after. Privacy is another significant difference. Wills become public record through probate, whereas trusts remain private. Additionally, the management and distribution of assets can be more streamlined with trusts, especially for complex estates. So, how do you choose the right option? Here are some questions to help you decide. What are your estate planning goals? If your primary goal is to ensure your assets are distributed quickly and privately, a trust may be the right choice. How do you feel about the probate process? Trusts can help your beneficiaries avoid the time-consuming and often costly probate process. Do you have minor children or dependents with special needs? Trusts can offer more control over how and when your assets are distributed, ensuring your children or dependents are cared for according to your wishes. What is the size and complexity of your estate? Larger estates might benefit more from the flexibility and control that a trust provides. Are you concerned about privacy? Trusts do not become public record like wills during the probate process. In conclusion, both wills and trusts have their unique advantages and can be tailored to meet your specific needs. It's always wise to seek professional legal advice to make an informed decision.
I'm healthy, I eat kale, so I don't need estate planning, right? Wrong. You need a power of attorney. Yesterday. If you get in an accident or end up in the hospital and can't speak for yourself, no one can legally help you. Not your partner, not your mom, not your best friend. Without a power of attorney, they might not even be allowed to talk to your doctor. Imagine this. You're unconscious, your bills are due, your pet needs food, your life is on hold. But with a power of attorney, your person can pay your bills, talk to your doctors, and keep things moving. Without it, they might have to go to court just to help you. And that takes time, money, and a whole lot of stress. So listen, you don't need to be old. You need to be prepared. Power of attorney. Get it, sign it, store it, because adulting means protecting your future.
Can you sell a house that is in trust? If you own property and are thinking about establishing a trust to safeguard your assets, many people ask, can you sell a house that is in a trust? The answer is generally yes, although the process can be intricate, requiring a thorough understanding of the various steps involved. In this guide, we'll walk you through the basics of selling a house that is in trust, including what a trust is, how it affects the sale of your property, and what steps you need to take to sell your home successfully. We'll also offer some tips on how to ensure your sale goes smoothly and efficiently, so you can get the best possible outcome for your situation. What is a trust? First, let's define what a trust is. A trust is a legal arrangement that allows you to transfer ownership of your assets to a trustee, who will manage those assets on behalf of the beneficiaries you name in the trust. The trustee has a legal duty to manage the assets in the trust in accordance with your wishes, as outlined in the trust document. There are different types of trusts, but the most common is the revocable living trust. With this type of trust, you can transfer ownership of your assets to the trust during your lifetime and retain control over them as the trustee. You can also name yourself as the beneficiary, so you can continue to use and enjoy your assets as you did before they were placed in the trust. The trust becomes irrevocable after your death, at which point the assets are managed by the successor trustee you named in the trust document. An important question to ask is, how does a trust affect the sale of a house? If you've transferred ownership of your house to a trust, the trust now owns the property, not you personally. This means that you can't sell the house yourself. The trustee must handle the sale on behalf of the trust. However, as the grantor, creator of the trust, you can give the trustee the power to sell the property by including specific provisions in the trust document. For example, you can include language that allows the trustee to sell the property at any time or only under certain conditions, such as when the beneficiaries agree to the sale. It's important to note that the trustee has a legal duty to act in the best interests of the beneficiaries when managing the assets in the trust. This includes the sale of the house. The trustee must make decisions that are in the best interests of the beneficiaries, such as selling the property for the highest possible price or using the proceeds of the sale to benefit the beneficiaries in another way. Here are the steps to selling a house that is in trust. Now that you understand the basics of how a trust affects the sale of a house, let's walk through the steps involved in selling a house that is in trust. Step 1. Determine the trustee's powers. The first step is to review the trust document to determine the trustee's powers regarding the sale of the property. If the trust document grants the trustee the power to sell the property, the trustee can begin the process of listing the property for sale. Step 2. Choose a real estate agent. The trustee should choose a reputable real estate agent who has experience selling properties that are in trust. The agent should have a deep understanding of the legal and financial aspects of selling a trust property, as well as the ability to work collaboratively with the trustee and beneficiaries. Step 3. Prepare the property for sale. Before listing the property, the trustee should prepare it for sale. This may involve making necessary repairs and improvements, staging the property, and setting a fair market price based on comparable properties in the area. Step 4. List the property for sale. Once the property is prepared, the trustee can list it for sale with the chosen real estate agent. The listing should include all necessary information about the property, including any disclosures required by law. Step 5. Accept an offer and negotiate. When a potential buyer makes an offer on the property, the trustee should review it and consult with the beneficiaries before accepting or rejecting it. If the offer is accepted, the trustee should negotiate the terms of the sale, including the price, closing date, and any contingencies. Step 6. Transfer ownership of the property. Once the terms of the sale have been agreed upon, the trustee should work with the real estate agent and the buyer's attorney to transfer ownership of the property. This may involve completing necessary paperwork and providing documentation related to the trust and the sale of the property. Step 7. Distribute proceeds to beneficiaries. After the sale is complete and any outstanding debts and expenses related to the property have been paid, the trustee should distribute the proceeds from the sale to the beneficiaries in accordance with the terms of the trust. Selling a house that is in trust can be a complex process, but by following these steps and working with experienced professionals, it can be a smooth and successful transaction. Thank you for tuning in, and if you have any further questions or need legal advice, feel free to reach out to us at Heritage Law Office. If you found this video helpful, don't forget to like, share, and subscribe for more informative content. Establishing an irrevocable trust can be a complex process that requires a comprehensive understanding of specific laws and procedures. This involves determining the trust's beneficiaries and transferring asset ownership into the trust. Guidance from a knowledgeable lawyer can make the process easier to navigate. Each trust is created for a unique purpose, whether to minimize estate taxes, to provide for a special needs family member, or to protect assets from creditors. Determining your purpose is essential to guide the rest of the setup process. Next, select the right type of irrevocable trust. There are various types of irrevocable trusts, such as charitable remainder trusts, life insurance trusts, and qualified personal residence trusts. Each trust has its pros and cons, and an experienced attorney can help you decide the most suitable one for your circumstances. The next step is to choose your trust. The trustee is the individual responsible for managing the trust based on your guidelines. This could be a trusted friend, a family member, or a professional trustee like a bank or trust company. The chosen trustee should be reliable, honest, and well organized. Next, you need to identify your beneficiaries. Beneficiaries are those who will ultimately receive the assets in the trust. It's crucial to clearly specify who these beneficiaries are and what they are entitled to receive. Next, you will need to create and sign your trust document. The trust document is the legal agreement that outlines the trust's terms, including the trustee's responsibilities and the beneficiary's rights. After the document is drafted to your satisfaction, it must be signed in the presence of a notary. Next, store the trust document safely. After the trust document has been signed, it should be securely stored. Both your trustee and beneficiaries should know its location and how to access it if needed. Next, you will need to transfer assets into the trust. The step of transferring assets into the trust is critical. Depending on the asset type, this may require changing titles or deeds or merely transferring funds. Remember, once an asset is transferred into an irrevocable trust, it generally cannot be removed. Here are some key considerations and benefits. The laws governing the creation and management of irrevocable trusts can vary depending on the state you are located in. Understanding these state-specific laws is essential for ensuring the trust's validity and its ability to meet its intended objectives. When establishing an irrevocable trust, it's crucial to consider the tax implications. Depending on the type of trust and the assets involved, there may be federal and state tax consequences. Now, we'll discuss the benefits of an irrevocable trust. An irrevocable trust is a legal entity that, once established, generally cannot be altered or canceled without the consent of the beneficiary. It offers several benefits like tax advantages, protection from creditors, and assurance that your estate will be managed as you wish. One of the primary advantages of an irrevocable trust is the privacy and asset protection it offers. Because the assets are no longer in your name, they are safeguarded from creditors and legal claims. Do I need a lawyer to set up an irrevocable trust? Establishing an irrevocable trust can be complex and mandates a thorough understanding of the law. A lawyer can guide you through the setup process, ensure all legal stipulations are met, and help you understand the trust's implications. Setting up an irrevocable trust is a comprehensive process that involves understanding various laws, selecting the right type of trust, choosing a competent trustee, and considering both tax implications and asset protection benefits. While it may seem complex, seeking the guidance of a knowledgeable legal expert, like those at Heritage Law Office, can simplify the process and help you achieve your financial and estate planning goals. If you have any questions, please leave a comment and we'll try to answer them. Don't forget to like and subscribe for more helpful content like this. Thank you for watching. When you pass away, your debts do not expire with you. Most debt still needs to be paid off if possible, although who is responsible for paying the debt depends on the type of debt, and some assets are protected from being used to satisfy a debt. Outstanding debt may include mortgages, credit card bills, car loans, personal loans, or condominium fees. Usually, your estate is responsible for paying any debts you leave behind. If the estate does not have enough money, the debts will go unpaid. In general, debt collectors may not try to collect payment from your relatives and heirs. However, there are some exceptions. Co-signers and guarantors of a particular debt are responsible for that debt, and someone who held property jointly with you would be responsible for any debts on the joint property. In addition, spouses in community property states may be responsible for some debt. Creditors are paid from the part of your estate that passes through probate, which means any property that passes through a will. The person who is appointed personal representative or executor of your estate is responsible for making sure the creditors are paid. The personal representative uses estate assets to pay off the debts before any money passes to heirs. If you have significant debts, it is possible that your entire estate will be used to pay creditors. Creditors cannot be paid from any assets that pass directly to a beneficiary. For example, a jointly held bank account would pass directly to the joint owner, and the funds in that account could not be used to pay creditors. Similarly, life insurance policies pass directly to the beneficiaries, so creditors do not have access to those funds. Whether or not a creditor can access funds in a trust depends on state law as well as what kind of trust it is. Contact Heritage Law Office to make sure your assets are protected. What is a funeral trust fund? A funeral trust fund is a legal agreement that allows you to put aside funds for your funeral and burial expenses. This ensures your final wishes are respected and eases the financial burden on your loved ones. Why is a funeral trust fund necessary? A funeral trust fund is necessary as it offers peace of mind, knowing your loved ones won't have to bear the financial burden of funeral costs. In addition, it provides assurance that your funeral and burial will be conducted according to your preferences. How to set up a funeral trust fund. Setting up a funeral trust fund involves several steps. Determine the amount, consider the type of funeral you want, and the costs associated with it. Include all potential expenses such as the casket, burial plot, and services. Choose a trustee. This could be a family member, friend, or a financial institution. The trustee will be responsible for managing and disbursing the funds after your demise. Create the trust document. This should be done under the guidance of an experienced attorney to ensure the document is legally sound. Fund the trust. You can fund the trust with cash, bonds, life insurance policies, or other assets. It's essential to discuss the most suitable funding option with your attorney. Legal considerations for a funeral trust fund. Funeral trust funds are subject to certain laws and regulations. It's crucial to understand these laws to ensure the trust fund operates as intended. An experienced attorney can guide you through the process, ensuring all legal requirements are met. Advantages of a funeral trust fund. A funeral trust fund offers numerous benefits to the settlor and their loved ones. These include quick accessibility of funds. Unlike other estate assets, funds in a funeral trust are immediately available upon the settlor's death. This eliminates any delay associated with probate and ensures funeral expenses are promptly covered. Flexibility. Funeral trusts can be tailored to meet your specific needs and wishes. You have the freedom to dictate the type of funeral service you want and how the funds should be used. Financial security. A funeral trust fund can alleviate the financial stress on your loved ones after your demise. Knowing that funeral expenses are taken care of can offer them much-needed peace of mind during a challenging time. Disadvantages of a funeral trust fund. While funeral trust funds offer numerous advantages, they also have certain disadvantages. Irrevocability. Some funeral trust funds are irrevocable, meaning once they are established, they cannot be changed or revoked. You should fully understand the terms and conditions of the trust before setting it up. Costs and fees. Creating a funeral trust fund may involve attorney fees and other administrative costs. It's important to consider these expenses when deciding whether a funeral trust fund is the right choice for you. Alternatives to a funeral trust fund. If a funeral trust fund doesn't align with your circumstances, there are alternatives. Life insurance. A life insurance policy can provide funds for funeral and burial expenses. However, these funds may not be immediately accessible upon death, depending on the policy terms. Payable on death account. You could set up a payable on death account at your bank. Upon your demise, the funds in the account are directly transferred to the named beneficiary who can use them to cover funeral expenses. Planning for end-of-life expenses is an act of kindness towards your loved ones. A funeral trust fund can be an effective way to ensure your final wishes are respected and your loved ones are not burdened with unexpected expenses. However, setting up such a trust requires professional legal guidance to navigate complex laws and regulations. At Heritage Law Office, we can help you create a funeral trust fund that aligns with your needs and legal requirements. If you have any questions, please leave a comment and we'll try to answer them. Don't forget to like and subscribe for more helpful content like this. Thank you for watching.
Imagine this. You've spent decades building your dream business, only to have it crumble because of a simple oversight in your estate planning. Sounds dramatic, right? But it happens more often than you think. Picture this. Your family is left fighting over your assets. Or worse, your business gets tangled in probate for years. Now, here's the kicker. Many people believe that just having a will is enough. Spoiler alert, it's not. Trust can save your loved ones from a legal nightmare, and they can even protect your business from unexpected taxes. Don't leave your legacy to chance. Plan ahead, avoid the pitfalls, and ensure your hard work doesn't go to waste. Your family and your business will thank you.
In this video, we will discuss the benefits of a living trust and how it can be a powerful tool in your estate planning strategy. A living trust, also known as a revocable trust, allows you to manage your assets during your lifetime and dictate how those assets will be distributed after your death. One of the key benefits of a living trust is avoiding probate. Probate is the legal process of distributing a deceased person's assets under court supervision. By placing your assets in a living trust, you can ensure a smoother, quicker distribution to your beneficiaries, saving time, reducing costs, and maintaining privacy. Another significant advantage is the control a living trust provides over your assets. You can manage your assets during your lifetime and specify exactly how and when your assets will be distributed after your death. This flexibility allows you to tailor the distribution to meet your beneficiaries' needs, such as staggering distributions for younger heirs. A living trust also includes provisions for managing your affairs if you become incapacitated. If you are unable to manage your assets due to illness or injury, your successor trustee can step in without the need for a court-appointed conservatorship, ensuring continuous management of your affairs. Flexibility is another key benefit of a living trust. You can amend or revoke the trust at any time while you are alive and competent, allowing you to adapt your estate plan as circumstances change. While a living trust alone does not provide estate tax benefits, it can be part of a comprehensive estate plan designed to minimize estate taxes. By integrating strategies such as irrevocable trusts or gifting, you can reduce the taxable value of your estate. A living trust can also protect your beneficiaries. This is especially beneficial for minors, individuals with special needs, or those who may struggle with financial management. Special needs trusts and spendthrift provisions within a living trust can ensure that your beneficiaries are protected and their inheritance is managed wisely. For business owners, a living trust can streamline the transfer of business ownership, ensuring a smooth transition and continuity of operations. This helps prevent disputes and ensures the business continues to operate effectively. Finally, administering an estate through a living trust is generally simpler and less burdensome for your trustee compared to probate. This results in lower administrative costs and a more straightforward process for managing and distributing your assets. In summary, a living trust offers numerous benefits, including avoiding probate, maintaining control over your assets, managing incapacity, flexibility, reducing estate taxes, protecting beneficiaries, streamlining business succession, and simplifying estate administration. Understanding special needs trusts. In this video, we will explain what a special needs trust is, its benefits, types, key considerations, and common mistakes to avoid. A special needs trust, or S&T, is a legal arrangement designed to manage assets for the benefit of a person with disabilities without disqualifying them from government benefits, such as Medicaid or Supplemental Security Income, known as SSI. The primary objective is to enhance the quality of life for the individual by providing financial support for needs not covered by government programs. Special needs trusts offer numerous benefits. They ensure that the beneficiary continues to qualify for essential government benefits, provide a steady source of funds for additional care, safeguard the beneficiary's assets from creditors, allow professional management of funds, and offer peace of mind to families. There are three main types of special needs trusts. First-party special needs trusts are funded with the beneficiary's own assets, such as an inheritance or a personal injury settlement. Third-party special needs trusts are funded by someone other than the beneficiary, typically parents or grandparents. Pooled special needs trusts are managed by nonprofit organizations and pool resources from multiple beneficiaries for investment purposes, while maintaining individual accounts for each beneficiary. When creating a special needs trust, there are several key considerations. Selecting the right trustee is crucial. They must be knowledgeable about public benefit programs and capable of managing the trust assets effectively. Funding the trust properly is also essential, with common sources including gifts, inheritances, life insurance policies, and personal injury settlements. The trust document must be carefully drafted to comply with legal requirements and protect the beneficiary's eligibility for government benefits. Regularly reviewing and updating the trust ensures it continues to meet the beneficiary's needs and complies with current laws. Avoiding common mistakes is important in maintaining the effectiveness of a special needs trust. Ensure the trust is adequately funded to cover long-term needs. Choose a trustee with the necessary expertise and commitment. Properly structure the trust to preserve government benefit eligibility and regularly update the trust to align with the beneficiary's evolving needs and changes in the law. Setting up a special needs trust is a compassionate and prudent step in securing the future for someone you care about. It provides financial security and enhances the quality of life for individuals with disabilities.
To date, we're going to talk about a topic that many might overlook: funeral trusts. A funeral trust is a legal arrangement you set up in advance to cover your funeral expenses. It ensures that the money you set aside will be used specifically for your funeral costs, alleviating financial and emotional stress for your family during a difficult time. A funeral trust is a financial arrangement in which funds are set aside to pay for your future funeral and burial expenses. This trust can be revocable, meaning you can change or cancel it, or irrevocable, meaning once it's set up, it can't be altered or revoked. So why consider a funeral trust? Here are a few key benefits. Number 1, financial protection. Funeral trusts can help protect your assets from being used for other purposes. This is especially important for individuals seeking to qualify for Medicaid, as funds in an irrevocable funeral trust are typically exempt from asset limits. Number 2, peace of mind. Knowing that your funeral expenses are covered provides peace of mind for both you and your loved ones. It's one less thing for your family to worry about during a time of grief. Number 3, cost control. By setting up a funeral trust, you can lock in current prices for funeral services, protecting you from inflation and rising costs over time. Now, let's talk about how to set up a funeral trust. There are a few key steps to follow. First, consult with a professional. Work with a qualified attorney or financial advisor to understand your options and ensure the trust is set up correctly. Next, choose a funeral provider. Select a funeral home or provider and decide on the services you want. This could include everything from burial or cremation to specific types of services and merchandise. Then, fund the trust. Transfer the funds into the trust. The amount you deposit will depend on the estimated cost of your chosen funeral services. Before setting up a funeral trust, here are a few important considerations. Firstly, decide whether a revocable or irrevocable trust is best for your situation. Each has its advantages and limitations. Secondly, understand that funeral trust laws vary by state, so it's crucial to be aware of the regulations in your area. Finally, choose a reliable trustee who will manage the funds and ensure they are used appropriately when the time comes. While it's a difficult topic to think about, setting up a funeral trust is a thoughtful and practical step that can provide significant benefits. It's about planning ahead and making sure your final wishes are honored without placing a financial burden on your loved ones. Thank you for watching. If you have more questions or need guidance on setting up a funeral trust, consult with a qualified attorney to explore your options.
In this video, we will explore how trusts play a crucial role in business succession planning. If you're looking to ensure the smooth transfer of your business to the next generation, stay tuned. Business succession planning is essential for the longevity and stability of a business. Trusts are a powerful tool in this process, helping manage and transfer business assets effectively. So, what exactly is a trust? A trust is a legal arrangement where one party, known as the trustee, holds and manages assets for the benefit of another party, the beneficiary. Trusts can provide several advantages in business succession, such as maintaining control over assets, offering tax efficiency, protecting against creditors, and ensuring continuity and stability. There are various types of trusts used in business succession planning. Let's briefly discuss some of the most common ones. Revocable trusts allow the business owner to retain control over the trust assets during their lifetime and make changes as needed. This type of trust can avoid probate, ensuring a smooth transition of assets to the beneficiaries upon the owner's death. Irrevocable trusts, on the other hand, cannot be modified or revoked once established. These trusts provide significant tax benefits by removing assets from the owner's taxable estate and offering protection against creditors and lawsuits. Testamentary trusts are created through a will and become effective upon the owner's death. They allow detailed instructions for asset management after death but require probate before becoming effective. Charitable trusts are designed to benefit a charitable organization while providing tax benefits to the business owner. These trusts can ensure that a portion of the business assets supports charitable causes. Using trusts in business succession planning offers several strategic benefits. Trusts can help avoid the lengthy and costly probate process, maintain confidentiality, ensure business continuity, provide flexibility in asset distribution, minimize family disputes, and protect beneficiaries. To implement a trust in your business succession plan, follow these steps. First, assess your business and personal goals. Determine your objectives for the succession plan and identify key individuals involved in your business. Next, consult with an experienced attorney to explore your options and create a tailored plan. Choosing the right type of trust is crucial, as it should align with your goals and provide the desired benefits. Draft the trust document, clearly outlining the terms and conditions, as well as the roles and responsibilities of the trustee and beneficiaries. Then, fund the trust by transferring ownership of the business assets into it. Communicate the plan to key stakeholders, including family members and business partners, to ensure a smooth transition. Regularly review and update the trust to reflect changes in business or personal circumstances. Consider the example of a family-owned manufacturing business. The owner, nearing retirement, established a revocable trust to transfer ownership to their children. The trust included specific instructions on management roles and profit distribution. By doing so, the owner ensured a clear management structure, tax efficiency, and continued business growth under the new management. In summary, incorporating trusts into your business succession plan can provide numerous benefits, including control, tax efficiency, and asset protection. To secure the future of your business, consult with a professional attorney and develop a well-structured trust plan today. Thank you for watching. If you found this video helpful, please like and subscribe for more content on business succession planning. Revocable trusts are often used to get the effects that most people are searching for when they get a will. Wills have an issue when compared to trusts in that, by law, they are routed through the probate process, which takes significant time and money. Probate is the legal process that occurs to your estate after you pass away. A properly designed and funded trust can completely avoid probate, bypassing the need for mandatory waiting periods, your information being publicly disclosed, and having the entire process monitored by a court. All forms of trusts are important asset planning and protection tools that have their specific place. For more information on wills or trusts, contact a professional.
Welcome back to our series on estate planning. Today, we're going to discuss funeral trusts and Medicaid and how they can be used for effective asset management. First,